Good afternoon. I'm Robert White, council member at large and chair of the Housing Committee. Today is Thursday, February 8th, 2024. The time is now 2:12 p.m. This performance oversight hearing will cover the Real Estate Commission, the Board of Real Estate Appraisers, the Rental Housing Commission, and the Office of the Tenant Advocate in that order. These agencies are critical to regulating our housing market and ensuring tenants are represented and supported. We'll start with the Real Estate Commission, or REC. The REC is critical in maintaining our community's real estate market. They regulate licenses for real estate brokers, salespeople, and property managers, educate new and current real estate professionals, and maintain a real estate guarantee and education fund. Their goal is to ensure that all consumers impacted by the real estate industry are protected and served with professionalism. The REC is chaired by Frank Petranton. It consists of 3 members who must hold a broker's license, 2 members who must have a salesperson's license, 2 members who must hold a property manager's license, 1 member who must be a licensed attorney, and 1 member who must be a consumer member who does not have a real estate license. The mayor selects all members. One way to ensure we can support REC and our real estate professionals is to ensure they have a fully functioning licensing system. The system has been a problem for quite some time. I look forward to learning more about this issue and how we can be helpful. After the REC, we'll hear from the Board of Real Estate Appraisers, or BREA. BREA has a vital role of regulating real estate appraisals. The board certifies, educates, and licenses appraisers, all while safeguarding the interests of consumers. The board, chaired by Tamara Pappas, consists of 5 members appointed by the mayor. 3 members must be licensed real estate appraisers, 1 must be a real estate broker, and 1 must be a consumer member. Last year, we discussed some of the board's goals, one of which was to ensure the appraisal process properly served every member of our community. I recognize the impact that accurate and fair appraisals have on our lives. Homes are not just pieces of land or assets. They hold memories and are backdrops of who we are. We know in particular the impact that racial disparities in appraisals can have on families. So I look forward to continuing to work with BREA to ensure the appraisal process is equitable, and will fight to create pathways to make the field more accessible. Our third agency today is the Rental Housing Commission, or RHC. We'll hear from Acting Chief Judge Hunter. The RHC has existed since the 1980s as a judicial and rulemaking authority. However, its formal independence from the Department of Housing and Community Development was only clarified a few years ago. The RHC handles 3 main duties. First, when there is a dispute under the Rental Housing Act, either the Office of Administrative Hearings or the rent administrator within DHCD will issue an initial decision. If the parties appeal the decision, the appeal goes to the RHC for review. Second, the RHC is responsible for updating regulations related to the Rental Housing Act. In the past couple of years, Council has changed the Rental Housing Act on a few occasions, like the Fairness in Renting Clarification Amendment Act that we passed through committee last year. This has led to the RHC updating the regulations to implement the law. Third, the RHC is responsible for publicizing annual adjustment figures indicating how much landlords can increase the rents in rent-controlled units. This was another area of great conversation last year when inflation rates were much higher than usual. I look forward to the Rental Housing Commission reiterating their role in that process today. I also look forward to talking to the RHC about what supports they need to move cases through efficiently. Last, we have the Office of the Tenant Advocate, or OTA. OTA, led by Director Johanna Shreve, is vital to our real estate housing ecosystem because its role is to protect, educate, and collaborate with tenants. OTA offers an emergency housing program and housing assistance when tenants face tough times. Whether in the courtroom or at the council, OTA advocates for some of the most vulnerable in our community to ensure their rights and interests are protected. My team hears from and works with OTA staff every day. At today's hearing, we'll be working to understand how OTA measures its success and how we can better support tenants together. I'm going to lay out some ground rules for our witnesses. Every witness should have received a copy of the witness list yesterday. I'll call those on the witness list in the order they appear on the list. When I do, staff will promote each witness from Zoom attendee to Zoom panelist so that you can testify. When you are promoted, you will drop out of the hearing momentarily and come back into the hearing as a panelist, after which you'll be able to unmute. Public witnesses will be provided 4 minutes to testify. Advisory neighborhood commissioners are provided 5 minutes. We have no public witnesses for our first panel. So we will now turn to the REC. All right, I'm going to swear in both REC and BREA. So let me pronounce it better. REC and BREA. So I'll ask you to stand and raise your right hand. Do you swear or affirm under penalty of perjury that the testimony you are about to provide to the Committee on Housing is the truth, the whole truth, and nothing but the truth?
I do.
I do.
Thanks. Mr. Trenton, you can begin your testimony when you're ready.
Thank you, sir. Good afternoon, Chairperson White, members of and staff of the Committee on Housing. I'm Frank Tranton, Chair of the District of Columbia Real Estate Commission. Thank you for the opportunity to testify on behalf of Mayor Muriel Bowser at today's hearings to discuss the activities and accomplishments of the commission in fiscal year 2023 to the present. I'm currently serving in my 6th year as chair, and I remain committed to continuing the work of the commission. As chair previously mentioned, our mission is to protect the public health, safety, and welfare of the district residents by assuring that licensed persons engaged in the practice of real estate transactions, as well as applicants seeking to engage in the practice of real estate transactions, have the specialized skills and necessary training required to perform the real estate services governed by the commission. I'm pleased to be able to work with an engaged group of fellow commissioners, along with a dedicated staff and legal counsel at the Department of Licensing and Consumer Protection, who work tirelessly to achieve that mission. I am joined today by Leon Lewis, who is the program director, program manager for the commission. Pursuant to district law, the commission consists of 9 members, including 3 real estate brokers, 2 property managers, 2 salespersons, 1 attorney, and 1 consumer member. Each real estate broker, salesperson, and property manager member must be licensed in the district. The attorney member must be engaged in the practice of real estate law. The mayor, with the consent of the council, appoints each member of the commission who serves a maximum of 3 full consecutive 3-year terms. The commission meets every second Tuesday of each month at 10 a.m., except for August. The current commission members are myself, Yolani Goldstone, who's vice chair and the attorney member, Edward Downs, broker member, Elizabeth Blakesley, broker member, Joe Borger, property manager member, Monique Owens, property manager member, Erica Black, salesperson member, Ramona Barber, salesperson member, and Patrice Richardson, our consumer member. The powers of the commission include determining the initial eligibility and renewal licensure requirements, establishing and monitoring compliance with continuing education requirements, continuing monitoring standards for the profession involved in real estate transaction, and recommending changes as needed, along with receiving and resolving complaints against licensed real estate professionals. Furthermore, the commission remains vigilant in our oversight of the real estate guarantee and Education Fund. Since I last testified before this committee on February 9th, the commission has successfully held all scheduled monthly meetings utilizing the Cisco WebEx platform, which conveniently allows the public to virtually attend and participate. While the need for social distancing during COVID pandemic was accommodated by the virtual meeting format, the commission continues to receive positive feedback from the licensees and members of the public on the virtual delivery method, and we will continue that practice as we have over the last 3 years. The commission decided to continue to hold its meetings virtually, at least hybrid, to allow for larger group participation of consumers. In fiscal year 2023, the commissioners attended the Association of Real Estate License Law Officials training pertaining to the administration of license law, promulgation of regulations, and enforcement practices. Attendance at the Arello training sessions also allows commission members and staff an opportunity to participate in leadership opportunities on the national level. Currently, 2 of our commission members, Elizabeth Blakesley and Edward Downs, serve on the Arello Board of Directors, providing DC national recognition for its education and enforcement activities. The commission also recently concluded the real estate renewal process for the next 2-year license period for all salespersons, brokers, and property managers. The commission's licensing process oversees licensing of approximately 1,500 new and renewing licensees, including brokers, sales agents, and property managers, serving the diverse needs of the population of the District of Columbia. Additionally, the commission, through the Department of Consumer and Regulatory Affairs, the predecessor agency of DLCP, promulgated final rules in December of 2020 to further ensure that licensed real estate professionals maintain professional and ethical competence in their areas of practice. The final rules were implemented by the commission during the 2021-2023 license renewal cycle. First, the rulemaking amends the pre-licensing education requirements for individuals seeking licensure as a real estate broker or salesperson to include additional education in the practice of property management. Second, the rulemaking requires 3 hours of property management coursework for all real estate brokers and salespersons seeking renewal, activation, or reinstatement. Third, the rulemaking requires 6 hours of property management coursework for all property managers seeking renewal, reactivation, or reinstatement. Fourth, the rulemaking requires every new applicant who applies for licensure via endorsement from other jurisdictions to take a 3-hour course in property management. Lastly, the rulemaking revises the procedure concerning assessment fees collected from licensees for deposit into the Real Estate Guarantee Fund, Real Estate Guarantee and Education Fund. Specifically, the rulemaking changes the date by which the commission either suspended or resumed collection of assessment fees imposed on licensees from January 1 to November 1 to better align with the licensing cycles for real estate professionals. The commission continues to expand its educational efforts through public-private partnership with local agencies and private organizations. During fiscal year 23, the commission and DLCP offered virtual courses on legislative updates, DC fair housing, broker supervision, and property management in the district. The commission, in conjunction with DLCP and the DC Historic Preservation League, also sponsored a series of in-person seminars on historic preservation in the summer of last year. The commission also offered an additional historic preservation course entitled Historic Preservation, Architectural Styles, and Online Resources. The commission continues to enforce the Occupations and Professional Licensure Act of 1998 by receiving and reviewing complaints from members of the public. For fiscal 23, the commission received 34 complaints, and as of the start of 2024 to the present, the commission received 18 complaints. The commission resolved and enclosed 20 complaints in 2023 and 2 complaints at this point in 2024. The commission values transparency and publishes newsletters regularly, as well as consumer alerts that the public and licensees can view online on the commission's website under publications and resources. The newsletters also include disciplinary actions taken against licensees by the commission, as well as articles for educational purposes and regulatory requirements. The commission will continue to dutifully carry out its responsibility of protecting the public interest and welfare by upholding the letter and spirit of the district's licensure law concerning real estate brokers and salespersons, as well as property managers. The commission appreciates the opportunity to share the accomplishments and plans for the future, and it looks forward to continuing to work with Mayor Bowser, DLCP, and the committee. Thank you for your leadership and support. This concludes testimony. The commission staff and I are happy to address any questions.
Thank you very much. And Chairperson Pappas, would you like to begin your testimony now?
Can't decide if I need my glasses or not. Good afternoon, Chairperson White, members and staff of the Committee on Housing. My name is Tamara K. Pappas, and I have the pleasure of serving as the chairperson of the District of Columbia of Real Estate Appraisers. Thank you for inviting me to testify on behalf of Mayor Bowser to discuss the activities and accomplishments of the board excuse me, in fiscal year 2023 and 2024 to date. I would also like to thank the committee for the continued support of the board's staff and legal counsel and the superb job they do to facilitate the many activities of the board. The board consists of 4 current members. We are missing 1 member. We do not have a public member. There is myself, appraiser member, Andrew Sullivan, appraiser member, Marty Skolnick, appraiser member, Anthony Bowling, real estate member. Although the public emergency and public health emergency have ended, certain operations that we implemented during that time continue as they allow the board to be more efficient. Specifically, the board continues to meet remotely via the Cisco WebEx platform. This virtual platform provides for a greater attendance by the public and appraiser licensees. The board has successfully held all of its scheduled meetings virtually, and the feedback has been favorable. The District of Columbia Board of Appraisers for fiscal year 2023. The DC Board of Real Estate Appraisers is uniquely situated as the only professional licensing board within the Occupational and Professional Licensing Administration that is federally regulated under Title 11 of the Financial Institutions Reform, Recovery, and Enforcement Act of 1989, commonly known as FREA. Accordingly, the board is mandated by Congress to follow FREA as amended and its accompanying rules and regulations. Additionally, the Board of Appraisers Subcommittee, or the ASC, created by FREA, is to ensure that the federal, financial, and public policy interests of the real estate transactions are protected by requiring the real estate appraisers utilize in connection with federally related transactions are performed in writing in accordance with the uniform standards and by individuals whose competency has been demonstrated and whose professional conduct will be subject to effective supervision. In general, the ASC oversees the real estate appraisal regulatory framework as it relates to federally related transactions as defined by Title 11. Throughout fiscal year 23, The board reviewed exposure drafts issued by the Appraisal Foundation's Appraisal Qualifications Board and the Appraisal Standards Board during fiscal year 23 and fiscal year 24 respectively. 176 new applicants were approved for licensure in 4 categories, including training, licensed residential, certified residential, and certified general. The Appraisal Subcommittee Off-Site Assessment. The ASC requires that an audit be conducted every 2 years to verify that the board is maintaining compliance with FREA. The board and staff members provide periodic reports to the ASC, as well as timely updates regarding disciplinary actions. The disciplinary actions are entered into a national database and maintained by FREA. The Appraisal Subcommittee conducted an audit of the board and DLCP operations in February of 2023. The board and DLCP operations received a good rating for the previous 2-year period. Efficient complaint investigation. Real estate appraisals are the result of the evaluation of several complex factors. The nature of the work often means that complaints from the public alleging faulty appraisals require an appraisal expert opinion. To ensure complaints are thoroughly reviewed in a timely manner, the board hires appraisers on a contract basis to review complex complaints. This process continues to work well and results in clear and comprehensive complaint summary reports submitted by the board's review in a timely manner. The national influence of the DC Board of Appraisers. The DC Board of Appraisers continues to be successful in maintaining our membership with the Association of Appraiser Regulatory Officials, or ARO. The spring and fall annual conferences bring together top regulator officials from around the country and keep the board abreast of key developments impacting the board's enforcement of federal regulatory requirements. Last year's spring meeting was held in person in Savannah, Georgia, on May 8th through 12th, 2023. I'm happy to report that the fall conference was held in person in Salt Lake City, Utah, on October 7 through 9, 2023. The board was well represented in attendance in both meetings. I completed my term as director on the ARO Board of Directors, as well as my service as on the executive committee. And I'd like to stipulate in here that Mr. Lewis is now on the current Board of Appraisers, so we're still, or Board of Directors, so we're still well represented. Although my term has ended, I remain active with ARO by serving as vice chair of the advisory committee for the Appraisal Qualifications Board as part of the Appraisal Foundation and a member of the program committee. The board continues to move toward expanding its educational offerings through public-private partnerships with numerous local agencies and private organizations. During FY23, the board sponsored 3 historic preservation seminars in person for all licensed appraisers with the DC Preservation Board and the DC Real Estate Commission. This year, the board will sponsor another 2 preservation seminars. Attendees will receive 3 hours of continuing education credits. These seminars represent a continuing effort of the board to ensure that our licensees are knowledgeable for both historic districts and disclosure requirements. Additionally, the board sponsored the Uniform Standards of Professional Appraisal Practice, or USPAP, update course at DLCP on December 1, 2023. Attendees received their 7 hours of continuing education credit. We will continue to maintain rigorous continuing education requirements for our licensees and offer board-sponsored courses for its licensees annually. The board has continued to process a process to assist our trainees in making sure that their work product and their logs are completed correctly, and to help them avoid any rejections by the appraisal board. This is done for a trainee and supervisor without any penalty and is meant to be as a learning tool. Our current initiatives. In FY 2024, the board will continue to work with the Department of Insurance, Securities, and Banking, or DISB, on bias in the appraisal process. Although the board has neither received any complaints nor is aware of any evidence of bias in the appraisal process, we remain vigilant in wanting to ensure equity and fairness in the industry. In addition, the Appraisal Foundation is developing a new online course requirement that will need to be completed by January 1, 2023. All real estate appraisers will be required to complete the new federal fair housing laws and understanding real estate bias for appraisers. This coursework will become a part of the appraisal criteria for new and renewing appraisers. The board will work with the DLCP staff to effectuate this change in our regulations. Lastly, the board will explore a partnership with DC Public Schools that will introduce students to careers in real estate appraisal industry. Additionally, the board will work with the University of the District of Columbia on establishing an appraisal academic program for persons interested in becoming an appraiser. In conclusion, the board members can consider our role a great opportunity to serve the citizens of the District of Columbia. We will continue to carry out the board's many responsibilities, including establishing high standards for pre-licensing and continuing education, investigating consumer complaints, penalizing bad actors, complying with federal requirements, and engaging in professional regulatory organizations across the nation. The board thanks Mayor Bowser, DLCP, and this committee for your leadership and support. We appreciate the opportunity to share its accomplishments and plans for continuous improvement, and look forward to continuing the work with the committee. In conclusion, this concludes my testimony. The board staff and I are happy to answer any questions you may have. Thank you.
Thank you both very much for being with us and for the work that you're doing. Mr. Lewis, thank you as well. Appreciate you being with us today. We'll jump into some questions. And let me start with you, Mr. Pye-Tranton. It's my understanding that your term and Ms. Goldstone's terms have expired because you reached your maximum service period. Have you heard from the mayor's office on when we can expect new appointments?
We have not.
Yeah.
We have not. Traditionally, we serve until our replacement is put into place.
Okay. Is this a normal issue on the REC?
I wouldn't say it's a normal issue. We had the unfortunate experience of the last two chairs dying in office. So I'm hoping from a personal perspective, that's not my fate. But we're happy to serve until somebody comes along who can take up the mantle.
How do you assess the effectiveness of, you all play an important role, mostly below the radar. How do you assess the effectiveness of real estate licensing exams?
I think our exams are pretty targeted to the issues that we face. We don't have a great number of complaints about questions or the inability to find the information needed to answer that question correctly. So I'm not aware of any issues with the exam.
Okay. Okay, so it would be like a complaint-based assessment and you haven't received any complaints.
Right.
Last year, we discussed the issue of the licensing portal being brought back in-house. I know you recently discussed with members of my team that the portal has still been an issue. Can you tell me a bit about what's going on with the portal these days?
I think the current efforts are outstanding in that they are not only looking at bringing this in-house, but we now have the resources available or have made the resources available that we can get this accomplished both timely and appropriately. We, for example, are using a Microsoft consultant to make sure that the process is both efficient and effective. And I certainly hope that we'll have this up before the next renewal cycle.
And this is the portal that current license holders and new folks would use to sort of get their licenses, stay current and all that. Okay.
Including the licensing exam process.
Got it. Got it. That's okay. So I'm sorry, let me go back. I got distracted. The is it going to come in-house or where are things? What should we be expecting in terms of improvements?
To my knowledge, it is coming in-house, or it is continuing to be done in-house. The previous 30 years, I think, were handled by a private company. For a while, a company called Pearson VUE, and then a company called PSI. Those were both third party, and it was deemed that it was time to bring that process in-house from a financial perspective. But we had difficulty getting a number of the features that we had become accustomed to working correctly, properly. I don't know. I haven't personally seen it. I know the staff has been very involved in reviewing the processes, and I think they're getting close to getting this online.
Okay. But you don't have a timeline at this point?
I don't. Perhaps Mr. Lewis does.
Yeah, we're working diligently. We meet with Microsoft twice a week, sometimes more than that. And we're looking at least something before the next renewal cycle, which is the early part of next year.
Okay.
Councilmember.
Early part of next year.
Well, the renewal cycle begins in December, January.
Okay.
And we hope to have something in place.
But before the renewal cycle begins? Okay. Please stay in touch with us about that if it looks like that timeline is going to slip, and if it's something we can do to help.
We hope to have that. And then our present system, we're working on some of the functionalities that are currently have been somewhat deficient, but we're working on improving those also to make them more efficient.
Okay. And I think Mr. Pytran, you mentioned you all offer courses to current license holders. Is that right?
Correct.
What kind of courses?
We require all of our licensees to have some property management courses. We do the normal brokerage and salesperson training, and we do a lot of fair housing and national concern issues as well in our education.
Okay. And so that is distinct from the Orello trainings that you mentioned in your testimony?
Orello is the Licensed Law Officials Association, and by belonging to that, we get to participate in a nationwide forum, if you will, to understand what the issues of licensure are, how to solve them, to take on new issues. There are always some issues coming before us. And we get to share those ideas with people around the country, so we are not reinventing the wheel. Oftentimes, some of the larger states find problems before we do. We're now looking at AI taking over the process of evaluating a property. There are a number of issues with that. We're looking at property manager. There's some deficiency in the licensing of the property management firm. So we have had individuals who are licensed, but they are not responsible for the contract of services that an association would sign. So there was sort of a loophole there. We're trying to correct that by getting the firms licensed, so that we know who's responsible and we can take care of a complaint quickly and easily.
What initiatives, if any, are in place? Well, let me skip here for a second. So one of your top goals that mentioned in your pre-hearing question responses is to draft legislation to regulate property management companies.
Correct.
Why is that?
Well, we wanted to mirror the situation with brokers and agents. A broker is named for a firm and we license that firm, then the agents are licensed under that firm. In property management, that's not the case. The licensee is an independent. We find that to be terribly deficient when an association, and we're talking about common interest communities, condos, co-ops, when they write a complaint about the property manager, it doesn't really have anybody to fall back on to answer that complaint, because the licensee is just simply dismissed, or the individual who's head of the firm said, well, you know, he was rogue. We don't know what happened to him, and there's nobody responsible. And that's become an increasingly an increasing concern, because you have a property manager who has access to an association's reserve funds. If it's a large association, those reserve funds could be in the tens of millions of dollars. So we want to make sure that there is somebody that we can look to say, okay, your person stole this money and you are responsible for getting it back. We can't do that unless the firm is licensed.
Right. And what are there any regulations currently with respect to property management companies?
Not with respect to the company. The individual has to be licensed
Okay.
as a property manager.
Okay.
And we're finding that there are a number of firms that are a number of individuals who claim to be property managers who pay no attention to the license requirement. We have some firms that say, oh, well, particularly with regard to common interest community, we're so much more than property managers. We don't need to be licensed. Well, in fact, we do, and I own a property management company. We do a lot more than just manage the property. We have to manage a board. We have to teach governance. We have to teach fiscal responsibility. And you can't do that if the firm that is responsible for the contract does not have a licensee under it that it can discipline, or in some cases make whole.
Okay. What initiatives are in place to promote diversity and inclusion within the industry?
I don't know that we have any new initiatives, but I am not aware that we have any real concerns in that regard. speaking for the commission itself, the old issue of everything is run by old white men is certainly not true. There are only 3 old white men on the commission. There are a predominance of women in the industry now, and that's reflected in the commission. My own observation in being a broker, an active broker and property manager, is that we see a great deal of diversity, not only racially, but ethnically and economically, if you will. It's not a rich man's sport anymore. It's there are a number of people who make an honest living in the real estate industry who are not, for lack of a better term, trust fund kids.
Okay, but there's no data here.
There is no data that I am aware of. I also am not aware that anybody has expressed a concern. I think the commission, the real estate industry per se in the District of Columbia has been very open in terms of diversity, equity, and inclusion.
If there was a concern, where would it go?
It could go to the Office of Fair Housing. It could come to us. It might not necessarily be directed to one licensee, which is what the complaints are generally filed. And it would probably end up going more to the council. As I said, I'm not aware that that's been a problem. We don't have any complaints based on their housing issues specifically, or there are, I am not aware of any complaints that we make it more difficult for individuals of color or ethnicity to get a license. The license itself is pretty free of those kinds. I suspect in any jurisdiction there are some hidden bias in the procedures, but we've worked over the years to make sure that wasn't the case.
Okay, I don't know that there is an issue. I wouldn't equate the lack of complaints to a conclusion myself that there isn't an issue. Without data, it's hard to know. For instance, I've done a lot of work in the mental health space, and in the social work field, we have data on test outcomes, and it's sort of glaring the outcome differences. And so we have data that help us draw the conclusion. If I were to look at the social work field in the district, I probably would conclude that there's no issue. So I will continue to kind of push to see how we can be more sure about whether there's an issue beyond mere observation. And so that's something I would like to continue to work with you on.
We're happy to work with you on that.
You also mentioned that you plan to conduct a fair housing instructor development workshop in your pre-hearing questions. How far are you into planning that workshop?
I think I'll turn that over to Mr. Lewis.
Yeah, we have an education coordinator who works with all of our boards, so he's in the process of coordinating a fair housing education workshop for our instructors. As a matter of fact, each instructor who teaches fair housing has to complete this workshop. So that will be planned within the next few months.
Okay. Would you move your mic just a little closer to you? I want to make sure folks who are watching have an issue. I appreciate it. I was able to hear you, but
Okay,
I know
thank you.
people watching may struggle. And is there a rough timeline on that?
We hope to get it done before the FY year ends.
Excellent. And has the commission seen, might have answered this already, but I want to make sure, has the commission seen any fair housing issues in DC? Bias, discrimination?
Not specifically. We don't handle a fair housing complaint. That's outside of our jurisdiction. But I don't believe the commission has seen a number of those. The nature of the complaints are normally more financial. Sometimes there's an issue of somebody misunderstanding what the licensee is supposed to be doing, ascribing more power to us than we have. But I'm not aware of anything in the fair housing. We don't have a number of complaints about those sorts of issues.
And you had mentioned also in your pre-hearing questions that you thought the seller disclosure statement requires maybe more information. Could you say a bit more about that?
As with all things, as we use them more and more, we find that there are some questions that remain unanswered. And so we have worked with the local associations of realtors to see where in the practice of real estate do we have problems. And we're finding that we need to make sure that disclosure statement is updated every now and then. There are questions now that were not asked 5 years ago when council came up with the disclosure. So we just want to make sure that that's kept up to date. There's always going to be the need for clarification.
Right.
Adding certain, categories of concern.
Are there any like categories or questions that you can think of offhand? Don't mean to put you on the spot.
Not immediately. I think we're going to be in a period where AI is going to be a big problem for us. Because the evaluation of a person's home is really a marketing technique. It comes across, and I've tested it, it comes across as instantaneous. In 10 seconds, they had my house, the right picture, the right number of bedrooms and bathrooms, all of those things were almost instantaneous, yet nobody, and they were comparing it to the house next door to me, which was a tear down. It's a new construction. Everything is perfect with it, where mine would be 35 years old. Nobody has put eyes on that. The machine can't see that if you're just looking at data. I think that's going to continue to be a concern. It's also a concern because they're offering these processes from outside the jurisdiction. And so I don't know that they're recommending licensed agents. So we want to try to keep tabs on that process and how that is working in terms of protecting the district, members of the District of Columbia.
Can you share a bit more about outreach programs you did last year with DC Public Schools?
This was an initiative started several years ago by Councilperson Bonds, and which was to make sure that we were doing some outreach to the high schoolers in the District of Columbia so that they understood the professions in real estate, and that they knew how to educate themselves for those positions. And some were just practical, like, what kind of money am I going to make if I'm a real estate agent? Yeah. That's a difficult question to answer for anybody, but we've tried to run programs where individuals in the district high schools can ask those questions of a professional, somebody who's been in it for a number of years. And I think those outreach programs have gone very well.
Excellent. How has it been getting into schools? Do you have to sort of develop a relationship with school leadership or?
No, we have partnered with people who are already doing that. And so it has not been difficult to get into the schools. It's been difficult to have a uniform program throughout the schools because the school calendar is very full and requirements for the teacher's time and for the students' time is not necessarily available There's not a lot of time left in their calendar. But where we have run those programs, we've had great attendance. And it's a little too early to see whether all of those students are becoming licensees or whether we have steered them away from the process. But they have been well received, both by the students and by the school.
I appreciate that. And what about engagement with stakeholders like consumer advocacy groups to gather feedback and sort of assess or address concerns? Do you engage with stakeholders?
We can if there is ever a need. We've not shied away from working with advocacy groups. Don't know that we have a program that initiates that because we don't know what areas, but certainly if there is an area, we would have no hesitation to move forward on it.
Are there any key advocacy groups that you are more likely to hear from in some respect?
I would imagine, I don't know of any that are key. I think there's probably the greatest concerns that we're seeing now are in the property management area. And that's mostly an education process, which we are attempting to address. But I don't know of any other areas that are of particular concern.
Okay.
Certainly, if you hear of any, please tell us.
I would certainly will. Ms. Pappas, or Chairperson Pappas, in the pre-hearing questions, I asked whether the board evaluated surveys or other mechanisms that would help ensure adequate feedback from licensees or members of the public. You all noted that you allow feedback during public meetings. In the past, meetings were difficult to access. Luckily, this issue has been fixed, but I still wonder how do you get feedback from the public about the appraisal process?
Well, like I said, the meetings, they're always welcome to come. And that's one of the top things on the first part of the agenda is we ask the public if they have questions or something. Sometimes they're very specific. A lot of times they're appraisers just listening in or saying, no, I just wanted to listen in. That's what they'll tell us. Now, we have obviously the complaint process where they can anonymously or otherwise, if they have a complaint about an appraisal, they can file that. And we certainly follow up on all of those. But as far as a specific program for them or a thought of how we would do that, if you have any suggestions, we'd be more than glad to act on that. We'd be very interested if there is any issues regarding that.
Well, I do always want, I don't have any suggestions right now, but I will think about this. The average person who goes through an assessment probably doesn't know about meetings or complaint process, which is why I think surveys may be worthwhile. I think it would provide some data that would.
What type of survey would that be? Just general out to the public? Are you?
Well, you know the process better than I do, so I would probably ask you like where in the process a survey might happen. I other than in the appraisal process, giving people an option to submit a survey that would go not to the appraiser but to you, is the only idea that comes to mind offhand.
See, our clients are going to be, not everyone, but majority through lender clients. That's who hires us. So lender hires us to, let's say you're refinancing your home, they're hiring me. I'm not allowed to discuss anything with that person
Mhm.
whose home I'm going to, other than I can explain general process, and I always do, because
Yeah.
I think it's important that they understand that I will count their basement, but it will be on a different line. You know,
Mhm.
I will, all your bathrooms count, but they may be separated out in this way. Anything that I think will cause a problem, a question for them that goes back to a lender, because that's where their questions go to. They go to the lender. I can, like say, I can talk about my general process, but when I leave there, I can't discuss value. I can't even talk to them if they call me. I have to refer them back to their lender. So not sure where in this process. Now on private, on a private appraisal, I explain the whole, everything to them because they've hired me. They're my client.
Right.
But I work for the client, but I also have to instill public trust.
Right.
So, it's, like I said, we're uniquely situated because we're governed in a completely different manner.
So would it be possible that for every appraisal done, that the person doing the appraisal would be required to notify the owner, whoever hired them, of sort of an optional survey, just for the purpose of getting feedback?
I don't know.
Okay.
I really, I don't know, because it's banking. The banking industry. I don't know if, our appraisal management firms are through banking.
Mhm.
They're through banking and insurance. So I don't know. And I don't know if the banks would ever send out a survey and say, okay, how
Well, they
would,
do send the appraisal, right? So if I apply for refinance,
they will send you a copy of the
I
appraisal.
get the appraisal. In the
Absolutely.
same email, they could say, hey,
Yep.
there's an optional survey.
They could do that. I can't. Is all I'm saying is I am bound. I can have no more communication about that appraisal
Right.
with you once I leave the house.
Right. So then where, if there was a complaint, where would it go?
First, it generally goes straight up to the client, which is the bank, if they have a complaint. So there's the request for reevaluation and if they say, well, I have these properties that I saw and I think they're comparable to my house, and they go to the lender and they say that, the lender will then come to me and say, would you please let us know, please consider these. We need a reconsideration of value. So they have that option. I go through them. If I look at them, I might say, I looked at that one. The reason I didn't use it was blah, blah, blah. And I have to explain each one. Very often I'll put properties in that I looked at very carefully but didn't use. I'll put them in there anyway to explain to the lender beforehand why I didn't use those properties. Sometimes, there can be a lot of reasons why you might not use a property.
So I just want to make sure I understand. So with regard to the board, if there is a complaint against an appraiser,
Right.
that would go to
That goes to the board.
the board. Okay.
Right. Well, like I say, they might go to their lender first. But the lender, unless they find something deficient
Mhm.
in the appraisal through their review process, they have on occasion sent a complaint into us, but generally that's going to come through the homeowner.
Okay.
Yeah.
I am interested, as you can tell, in getting more information about this. I think it is an issue nationally, and I might have shared this in a previous hearing. It's an issue that I've experienced. I was living in a house, property values around us kept going up and up. We needed to, I think, get a new roof at the time. The appraisal seemed very low. The appraiser said, I wouldn't bother doing work in this house because the homes in this neighborhood are not going to go up very high. And
Whoa.
just in the next 3 years, they went up astronomically, which I could have told them because I'm seeing it every day. And so I know it's a national issue. I've been through this issue myself.
Right.
Anytime I get an appraisal done, I take black stuff off the walls, if I can just be frank. I'm not the
Mhm.
only one. This is common. So that's why I'm eager to learn more. Like,
Sure.
it could be an issue that's, isolated. It could have been a bad appraiser, could be more prevalent.
Right.
But it is an issue. I think a lot of folks in the Black community would say they feel that way about appraisals. If it is an issue, I would want to address it.
Sure.
If the data doesn't bear it out, I would want to sort of know that to settle it. So
Right.
I am eager to see how we can understand this issue better, to understand, is it an issue we need to address or is it not?
Right. Well, we certainly are with the initiatives that I told you about with fair housing. I mean, in our original use PAP, our standards, it's clearly stated there with regard to ethics that you can't be biased. I don't like your pink kitchen. Well, you know what? I don't get, I have to be blind to that pink kitchen. It's got brand new, very high-end, expensive, everything in it. It's an excellent kitchen. It doesn't matter that it's pink. I can't see pink. So with regard to anything that's on walls that would indicate anything about a person's personal preference for anything, and that goes for all protected community categories, they're blurred out. I saw it, but no one beyond me is going to see it. Yeah, and that's the way, that's my opinion, that's the way it should be. But yeah, I mean, we have to admit it exists.
Yeah.
Yeah.
And there's not supposed to be bias,
Right.
which doesn't mean there isn't. And I'm trying to figure out what is.
How to navigate that and help to mitigate it.
Right.
It's really important.
Yeah.
And for the appraisers, they will be getting that 7-hour course in bias and fair housing that everyone will have to take. And from there on out, it'll be a 4-hour course.
Right. And I think that's a great step.
Yeah.
I do think though, without data or sort of a known feedback loop,
Yeah.
it's going to be difficult.
Yeah, I appreciate that because like yourself, you didn't know where to go or what to do about that. You had no way to,
That's right.
yeah, or any way to make your concerns
Right.
known. And I think it would be great if as a board that we could hear those concerns from the public. I just don't know how to extrapolate that information, how to bring it in-house to figure it out.
We will bat around some ideas with you and utilize your expertise to
Well, you
figure
have
out-
us on your team,
I know
so
it,
yeah,
and I appreciate it.
yeah.
You sort of still along the lines of outreach. I know the board's goal is to release newsletters periodically.
Right.
How's that going?
Well, we had one come out recently.
Great.
It's not happening quite as often as I'd like it, because but I'm sure we'll get another one in a few months because we do have this, got to get this information out to the appraisers. They're going to be required to take this course and it's going to be made available. The board and Mr. Lewis and the whole team, just like we did for the standards course, we hope to be utilizing our education fund and for our DC licensees, if they want to come in and I don't know that it's only going to be online, but it'll be in person too. And get that to them, get them in person and make sure that that we can give that to those who will come into the office and do it. So.
And so with the newsletter and the meeting links, is the board is still having some trouble uploading those to the website?
We're constantly looking at our website for improvements. the newsletter that Chairperson, Pappas mentioned, that was recently done. So in terms of our website, we're looking at additional, we have a lot of information on there. As you know, the board is a federally regulated board. So it has all of the appraisal foundations information as well as the qualifications that one has to meet in order to become licensed in the District of Columbia. But there's always room for improvement. My first supervisor told me that, and we're constantly working on that.
All right, so I take that to mean that the issues uploading those links are persisting.
No, we just, one is there in terms of the appraisal newsletter.
Okay, and the newsletter and the meeting links as well?
The meeting links should all be there.
Okay, excellent.
Yeah, I think we did have an issue. It wasn't highlighted or activated or whatever that was, but that got immediately taken care of. So
Right.
now I remember what you're talking about.
Okay, gotcha.
Yeah, it wasn't, they weren't activated. Yeah, yeah. So yeah, we did get that we did get that taken care of. We are in the middle of our renewal process, actually almost at the end. January 20, well, we have 29 days this year, don't we? I think, but anyway, the end of February, all licensees, and we've had an excellent turnout. People, we made it active in December, and people started filing, uploading all their CE credits, everything. We're up to 997 appraisers with licenses now. It used to be 7. It was like 718 or something. Yeah.
Yeah, between 7 and 8.
Yeah.
Okay,
So,
that's
so,
great.
yeah.
Almost.
And we have the new PREA out for our trainees is available now. We only have one provider at this time, but still it's there. And,
And the issue of complaints against licensees,
Yep.
how many complaints were there in FY 23?
did you have that total?
Yeah, 10. It's covering
You hit the button.
Sorry.
Yeah.
We had 10 complaints covering the reporting period.
Okay. And what's the process of investigating those complaints?
Well, with this board, the board hires via contract a review appraiser. So when the board has reviewed the complaint and determines that there may be violations, and usually the violations are in the area, there's something called USPAP. That's the Uniform Standards of Professional Appraisal Practice that all licensed appraisers must follow. So usually if a complaint comes in and the board reviews it, and if there are possible violations, then it goes to a review appraiser. And that review appraiser reviews the complaint, determines whether there are any violations of USPAP, pretty much. And then it comes back to the board for review and possible action.
And our review appraiser is an expert in USPAP.
Okay.
Knows all of our standards, standard 1-1A,
Yeah.
right down the line. And it, all the different areas, the ethics, record keeping. I mean, there's every aspect of USPAP gets reviewed. And that's where we hold them accountable. When it comes to if it appears to be a value issue, that's a tough area. Unless another appraisal is done, it's almost like because
Yeah.
you have to have someone go and do the whole process. We have one we're working on now that has an issue with size. We actually had our review appraiser go out and remeasure the house. It's like, okay, which is right? What's the right number? So.
Okay. So these are complaints about the appraisal and not so much about the appraiser. Is that right?
Yeah, it's about the
Well, they're-
result. Yeah,
yeah,
the
they're
result
connected
of the
to
appraisal.
Each other.
Yeah.
The appraiser and the appraisal.
Yeah,
So if there are violations found, and we just had a case where a fine was levied on the individual along with corrective action because our board is pretty active in trying to correct or require corrective coursework, education coursework on the behalf of the offending appraiser.
okay.
Yeah,
And-
so if they have an issue, let's say they had a violation, an ethics violation or a record keeping, they had no, their work file was solely deficient. They had no evidence of how they did their appraisal. There are the appraisal foundation has coursework that you don't get to keep the credits from. You have to take it. And because we really do believe in educating our appraisers, if there's a discipline required, obviously that too. But, it's like you were deficient in this aspect of your appraisal. You really need to go learn more about that part of the appraisal process,
Right.
trying to elevate them.
And when an appraiser is fined, where does the fine go?
But the fines go to the
Okay,
bylaw.
Then we spend it on the appraisers for education. So,
and how do residents know they can submit a complaint?
It's on our website. It's on our website.
Your mic may be having an issue. If you press that button.
Oh,
Is it-
there
there we are. Yep.
No, it's right.
I get it after a while. There's a complaint process on our website in which the forms are there for them to file. And we haven't had any issues in that area, or they'll call, if an appraiser has done something allegedly wrong,
Yeah.
but it's on the website.
But how would you know that there haven't been any issues? Because my guess is the average person doesn't know the agency or the website.
Well, there's a number of sources. There's a national hotline network maintained by the appraisal subcommittee. If there are violations, and that's in addition to our website, there's a hotline that the public can go to.
And to your knowledge, does any jurisdiction send to people who get appraisals information on sort of, where you can share concerns?
Well, we have our national conferences, and that's where groups gather, appraiser groups, societies, associations, and anybody who wants to come to their conferences. So we gather information there in terms of what other states and jurisdictions are doing.
I guess what I'm asking is I want us to put ourselves in the shoes of the average resident. Gets an appraisal, has a complaint or concern about something. Does the average person know that they can call someone, that the website exists? Do you think the average person knows?
No,
Probably not.
I don't think so. And thinking along your lines, what housing does, what you guys do, when they hand them all kinds of information to read, right? Yeah, and yeah, we don't have that in our toolbox.
Yeah.
I don't know how we go to our next conference in Nashville, maybe we'll go to those people at those upper levels and see if there is anything like that.
Okay.
Yeah, I mean,
hope
I
we'll-
see what
yeah.
you're saying.
Yeah.
Yeah.
And we'll work with you on it as well and try to bat around some ideas. I just think if people know, then I feel much more settled about where we are.
Right,
but-
if all of our appraisers, if they were required to, whether a very generic handout.
Yeah.
Okay, this is the appraisal process, this is what's going to happen, this is what rights you have.
Right.
You have the right to, get a revision, request a review of your value. If information is incorrect, that they have
Yeah.
an avenue.
I think that's right.
Yeah.
And it's just, it's such an important thing. Property is for most people, the most valuable asset. The appraisal will sometimes dictate the next property you can buy, whether you can sort of get that repair made, what have you. It's such an important thing. I want to make sure we are always serving residents as best we can.
And if they actually understand, although the bottom line is what's important to them, that's where they go first.
Yeah.
But it would be good if they understood how that got there, how we got there, that it isn't just Zillow or it isn't just,
Right.
AI, that the house next door, there might be extreme differences with that house if
Yeah.
it just sold and, it's a very complex process. I mean,
Right.
they're 60, 80 pages thick, not that it's all written, but it's all documentation.
Yeah.
So,
Well, I want to thank you all for being with us today. Again, thank you for the work that you and your colleagues are doing. I'm excited about some work that we're working on
Looking
together already. some
forward
things
to
that-
UGC.
That's
and
right.
I'm going to talk to Frank at how he got into schools because
Yeah.
I don't seem to be able to get in there.
Well, I think Frank has the plan.
Yeah, he
and
does.
we're here as a resource as well. So thank you again for being with us.
Thank you much for having us. Thank you.
And we are going to move to our second agency for today. Gonna move to, thank you, the Rental Housing Commission. Judge Hunter, I passed you in the hallway, wasn't even focused, didn't realize till I got in here.
That is
That it
fine.
was you, but it is good to see you, good to have the team here. Before we begin, it is the practice of our committee to put all government witnesses under oath. So I will ask that you all raise your right hand. Do you swear or affirm under penalty of perjury that the testimony you are about to provide to the Committee on Housing is the truth, the whole truth, and nothing but the truth?
I do.
Excellent, wonderful. Well, thank you again for being with us, and you can begin your testimony.
Thank you. Good afternoon, Chairperson White and members of the Committee on Housing. I am Adam Hunter, Acting Chief Administrative Judge for the Rental Housing Commission. I am joined today by Dan Meyer, the General Counsel, as well as Judge Toya Carmichael, who's to my left. Thank you, Mariel Bowser, for the appointment as the Acting Chief Administrative Judge and the opportunity to serve this commission and the district in this new role. Thank you to the commission's staff for helping to prepare the report for this oversight hearing. I am pleased to have the opportunity to present the commission's performance oversight testimony for fiscal year 2023 and 2024 to date. As you know, the Rental Housing Commission serves three key roles in implementing and enforcing the Rental Housing Act of 1985. First, the commission acts as a specialized intermediate appellate court, hearing and deciding cases between housing providers and tenants, where one or both parties are appealing a ruling by the Office of Administrative Hearings. Second, the commission determines and publishes the annual rent adjustment and general applicability for rent stabilized units. Third, the commission is charged with issuing, amending, and rescinding regulations to implement the Rental Housing Act. I would like to start by discussing the commission's appellate cases. These cases primarily involve the Act's rent stabilization program, commonly called rent control. and related issues like housing code violations, notices to vacate, and retaliatory action. On appeal, the commission reviews OAH decisions to ensure that the act was correctly applied and that procedures of OAH were correctly followed. The commission receives a copy of the full record from OAH, including transcripts and audio of all hearings, gives the parties the opportunity to mediate their dispute, consider any preliminary motions filed by the parties, and sets a schedule of written briefing and oral argument. After the parties present their arguments, one administrative judge and one staff attorney take primary responsibility of drafting a decision. Decisions are reviewed and voted on by the entire three-member commission. The length and complexity of a decision varies greatly depending on the nature of the underlying claims and the issues raised on appeal. In FY23, the commission's decisions range from 10 to 40 pages. As discussed in our written responses, and as we have discussed in prior years' performance oversight hearings, the commission has been working with the city administrator's office to develop performance metrics that accurately reflect the commission's process and holds the commission accountable for moving cases through this process in a timely manner. The commission has looked to other appellate courts across the country to develop targeted numbers to measure performance. However, baseline metrics and targeted numbers are not ultimately determinative of an appellate court's successes. Ultimately, getting the legal analysis and conclusions right will always be the paramount goal of the commission's decisions and opinions. Commission's decisions can be appealed to the District of Columbia Court of Appeals, and here, our appellate review success from the DC Court of Appeals has stood for the last 6 years without a reversal. We take this as the best evidence that the commission is serving its most important function, doing justice for the parties before it. With regard to the annual rent adjustment, last year was an historical outlier because of the high rate of inflation. The commission timely published the adjustment in February 2023, based on the statutory requirements for how it determined the inflation rate, which resulted in an 8.9% maximum allowable rent increase. As soon as the council enacted emergency legislation to reduce the statutory cap to 6%, the commission published a supplemental notice. This year, the commission published the annual notice in January based on the newly enacted legislation extending the tenant notice of rent increase from 30 days to 60 days. And effective May 1st, the maximum allowable rent increase will be 4.9%. I know there have been some confusion in the past, and our general counsel will be happy to answer any questions in detail about the commission's process for calculating the annual adjustment. Finally, with regard to rulemaking, the commission is dedicated to keeping on top of the legislative developments and monitoring issues that arise from the existing regulation. At the end of 2021, the commission published a 200-page omnibus rulemaking that made much needed updates and corrections to regulations that had not been amended since the late 90s. In early FY23, the commission published a short rulemaking with several technical corrections that were identified through our collaboration with the rent administrator to update the forms her office publishes for use by DC residents and businesses. Also in FY23, the commission published a proposed rulemaking to update the existing rules on eviction and add new rules implementing the tenant screening protection that were enacted by the council. While the commission was considering the public comments received to the proposed rulemaking, the council was moving forward with further amendments and clarifications to the eviction and screening provisions of the Rental Housing Act. After the final passage of those amendments, the commission began drafting a second notice of proposed rulemaking on those subjects, which we expect will be published for public comments this month. This concludes my remarks. Thank you all for your opportunity to testify today, and I'm happy to answer any questions that you may have.
Excellent, thank you. May also acknowledge Judge Gregory, who's
Yeah.
here, not testifying. We've had the pleasure of having Judge Gregory with us before. And I understand that you were just appointed acting chief judge this week after former Chief Judge Gregory exceeded her holdover period and was not immediately reappointed. Is that right?
That is correct.
Okay. Do you expect that the council will get an appointment resolution soon?
I do expect it to happen, yes.
The written responses show that about $45,000 in, and this would be question 16, the pre-hearing questions, about $45,000 in terminal leave, and the severance pay was paid to the commission's former chief of staff, who's no longer with the commission. Who makes the decision on severance pay?
Severance pay is made by the chief administrative judge as well in conjunction with the budget office. And I think if the general counsel has any further explanation on that issue.
No, I mean, that's right. It's the commission has independent personnel authority, and under the CMPA and the district personnel manual, it goes to the personnel authority to decide severance pay. Terminal leave obviously is your accrued vacation time that has to be paid out under DC law. And for any other involuntary separation, the personnel authority can decide to give severance pay. This was a situation of the position was eliminated. So.
Okay. I appreciate it. I don't see an issue, but I like to go through these questions because sometimes the public does, and I want to make sure we have a discussion so we can highlight these issues. In September of 2023, $35,000 was reprogrammed to the commission for year-end personnel services. Was this used to pay part of the former chief's severance?
No, that was for salary. And given that at that time, the newest judge, Judge Carmichael, was just joining on to the commission. And as the budgeting process was happening, we were hitting all the targets quarterly. But when her onboarding came, that's when we started to recognize that there was a shortfall in the budget at that point, and that's when the reprogramming took place.
Okay, thank you. And the pre-hearing responses say the commission would like more money for two things: a junior staff attorney position and consistent trainings for staff. What role do you see the junior staff attorney playing on the commission?
Well, first, according to the statute, each judge is supposed to be given a law clerk. That we currently don't have funding for any law clerks for either of the judges. So part of the role of the junior staff attorney would be to continue to assist both the general counsel, work with the other staff attorney, and the individual judges on the decision writing, researching, and also with working with our regulations that we have to consistently update.
How many judges are there?
There are 3 judges.
3 judges, and how many staff attorneys?
We have 1 staff attorney and our general counsel.
Okay. And you said the statute says that each judge should have a staff attorney,
A law clerk.
a law clerk.
Correct.
There we are. Okay. How many law clerks are there?
We have no law clerks.
Okay. And is that a matter of funding, recruitment?
It's funding.
Okay. What impact is that having, the lack of law clerks?
Well, one, it takes more time to review case law research. As you know, as an appellate court, there is an extensive review of the lower record. And the lower record includes all testimony all hearing transcripts. Sometimes there are no transcripts. It's listening to recordings of testimony, looking over exhibits. These are very exhaustive hearings that are happening where we're looking over those records. Law clerks are helpful in helping us go through those records, helping us draft as well as do legal research, but more importantly, prepare for hearings as well.
Okay. I am sympathetic. This is as a former law clerk who did some of that stuff. And on the training piece, what kind of training do you hope to add?
So in the past, I know myself and Judge Gregory went to a legal writing and rhetoric training for judges, which means that our decision writing is better, more logical. That type of training is necessary so that we're doing the best work as judges. Also for staff attorneys and general counsel to have the same type of training is necessary that we're giving out the best work product in our decision writing. Also, implicit bias training is one area that would be nice to have staff as well as judges participate in. They do that at the Superior Court, implicit bias training. But right now, our budget in regards to training is not there. So that's one area where we're trying to increase training.
Is there, what standard training is available for incoming judges?
Well, right now, any incoming judge works with the current general counsel, staff attorney, and the other judges in getting up to speed on our cases and how we address dealing with our cases before us.
But in terms of the legal writing, in any of these other things that you're going to have to do, drafting opinions, you learn it on the job?
A lot of it is learning on the job, learning from our colleagues, and resting on some of our past experiences with our experience we have individually as attorneys and sometimes as administrative judges.
Now, we have a number of administrative judges in the district. Are there trainings that they have that could be made available to you all?
It's possible. I'm not sure if Dan or Toya could speak to that.
Good afternoon, Chairman.
Good afternoon.
Previously, the commission did send new judges to the National Judicial College. They have a 2-week training for new judges that is for judges and hearing examiners and hearing officers from all over the United States, as well as judges who are presiding over cases in other countries. I did have the opportunity to attend that training as a new judge for the Commission on Human Rights, but I know that that was one training program that was pretty standard at the commission and across the district.
And I will add, I did not attend that training. I attended the other training, but I do believe that the prior judges on the commission, including Judge Gregory, also participated in the one that Judge Carmichael was speaking about.
Okay. And just so I'm clear, is there a training budget now, but it's not enough, or is there not a training budget?
There's not a training budget.
Okay. That's less than ideal. Okay. Last March, the Board of Ethics and Government Accountability's Office of Open Government found that the commission was not in compliance with FOIA requirements because the commission had not made all final orders publicly available on its website. The commission agreed and immediately made changes to its procedures. Can you talk more about this? What changes did you make to get into compliance?
I'll let the general counsel answer that.
Yes. Yeah, our website, when we initially set it up in 2019 as becoming an independent agency, is still, frankly, it's a bit rough and ready, standard template from Octo on setting that up. And we were frequently, decisions were getting posted sometimes along with hearing notices or going back to hearing notices and adding it as a sort of attachment to those. The process was kind of being inconsistently followed and wasn't ideal anyway. It made it very hard to find these things. What we managed to do was set up a commission Google Drive account. And at least now we have all our decisions, orders, hearing videos posted to that. Our process is more standardized, so we're doing it as things are happening, as decisions and orders are coming out. So they are all posted there. I think we want to keep working with Octo. It's something we mentioned for our priorities for this year. Something better than that. It's not really searchable. It's never going to be something like Lexis or Westlaw, where the kind of terms and connectors searches that legal professionals use, but better sorting, better categorization are definitely things that we want to see improved along those lines. And we now have our decisions online. Initially, we got as far back as 2019 when BIGA first brought this to our attention about the proactive posting requirements. We got a few years done within just the 30 days they gave us to respond, and have since put in the time to go back and upload back to 2001 as the statute requires. There are, of course, commission decisions going back to it being the Rental Accommodations Commission under the 1975 Act. Possibly we'll manage to get those up too. Again, I think the priority is getting a better system, but we do have them publicly available now.
Okay. It may be worth a conversation with the Contracts Appeals Board. They had a similar challenge. They were able to get up to speed with some funding, but they did have a similar challenge, relatively similar size body as you. But I do think it's worth talking to them. Who uploads those cases and does the sort of IT work there?
Our clerk, Latanya Miles, and Alim Al-Musawir, our staff assistant, I think also is uploading as they come out. So.
Okay.
And I have seen Contract Appeals Board, and I think OEA has a very similar, the Office of Employee Appeals, similar system. So I think we don't need to reinvent the wheel here, but I think it may cost some money. So it's, who do we need to?
Yeah, I think that's right. I also think CAB ended up getting an IT person as well, if I remember correctly. But I think it's worth talking to them about what they use, how they got there, because you're right. You don't have to reinvent the wheel. So far in fiscal year 24 and excluding 2 outlier cases, the average time between oral arguments and disposition for commission cases has increased by almost 100 days, from 322 days to 434. What's causing the delay?
Well, I think one of the cases, I know there are 2 outlier ones. I know there was the one case that was from that was heard back in 2021. Part of that was the transition period between before I believe I came on to the commission, and then there was another commissioner or another judge was appointed to Superior Court. So I believe there was some time between transition of judges that were happening at that time.
Your question was the difference between FY 23 and 24
Yes.
numbers. I think the short answer is dropping the outlier. There's been one decision issued so far in 24, and that one took 434 days, which is not ideal, but that was a case of particular complexity. So,
so I'm talking about. So I'm excluding the outlier cases, and
the one other that's issued so far in 24 was 434 days. So that's an average of 1.
Okay, I'm with you now. What is there a systemic issue here that needs to be fixed, or is that sort of not an outlier case, but it was the issue more circumstantial.
But as to the 434 days that
Right,
one case
yeah.
took, I think that was just the complexity of that one case. I think we all hope and expect that, there will be decisions coming out in the remainder of the fiscal year that'll be closer to, some of those ones that you see for FY 23 that were 120 days, 156 days. And so the FY average will come down. Ideally, everyone would get their decision almost immediately, but sometimes your decision's in line behind a case that's going to take 434 days, or sometimes the case is just that complex. So I don't think that that's not on its own a systemic issue,
Okay.
other than, I think, to the point Judge Hunter was making of more staff, we can do more work faster, more cases at the same time will bring down the average for everybody.
How many cases have come in so far this fiscal year?
New cases?
Yes.
That is just a couple, I think. I can't remember which that number that was in our responses. It is in our written responses. Just two so far this fiscal year.
Okay.
And a number of other ones, of course, that are still pending, that either have been heard and decisions are pending, or were filed and haven't been heard yet. We will still be needing to send out briefing schedules or mediation. They're somewhere in the process. So,
Okay.
all of those will at some point be ripe for a decision.
And looking at last year's annual report, the commission decided cases related to claims of illegal rent increases, approvals of special rent increases, repairs of housing code violations, retaliation against tenants, and returning security deposits. What types of cases do you see the most?
I don't know if I really think of it as the most. I think they kind of all range with what you have just spoke about. It really all depends on that individual litigant's issue that they have for OAH and whether or not they feel they have an appealable right there. I don't know if I look at it as a specific. I see more of this versus that.
Okay. And that may answer this question as well, but maybe not. Have you seen any trends in rental housing or in the commission's cases that you think indicates something that the committee or the council needs to focus on?
I have not recognized any trends based off of what has come to our attention at this point. But I would also note that by the time matters come to us, there's also been a significant lag between when a person, their 3-year statute of limitations, when they decide to file, as well as they've made their way through OAH process, which takes a considerable amount of time. By the time we get something, we're probably looking at matters that are probably addressing issues that have happened years prior to it hitting our commission. So noticing trends, I think, is probably closer to the actual individual filing than what we do at the appellate level.
To illustrate that point, I think an example would be, someone might have several complaints, housing code violations, rent increases of debatably the right amount. They may go through a full hearing at OAH, get a ruling on the housing code violation issue, and then also on the rent increase issue, but it only comes before the commission then, for example, on, was the number on some form correct for the rent increase? And, the commission needs to decide that, very technical matter of how the Rental Housing Act is supposed to work. We may sort of incidentally see, oh, this was also something that came out of a bunch of housing code violations, but it doesn't necessarily make it into, this is a commission decision about housing code violations. Although I would say overall, historically, housing code violations is probably the most common, that it, typically makes it into something, somebody's complaining about the rent. And then, now that I'm on it, by the way, I've had a roach problem.
Right.
And I would also note, we just issued our new rulemaking. Any challenges to new rulemaking that has occurred probably won't make it to our commission, maybe even within this fiscal year, may take another year or two before we even see what happened from our current rulemaking.
Why would it take that long?
Once it goes,
Oh, I see. Once it goes into effect. Okay. I'm with you.
Yes.
Okay. Issues resulting from the new rules.
correct,
Okay. I'm
correct.
with you. Something I'm curious about, rent increases are pretty tightly prescribed in the law, sort of what's allowable. What are some examples of rent increases approved by the rent administrator that RHC has overturned?
So there's only a few instances where the rent administrator, or now generally it's going to go to OAH for a hearing on the merits of that sort of thing. The few instances, the housing provider petitions, hardship petitions, capital improvement, substantial rehab, voluntary agreement, and service and facilities adjustments. Recently, one of the cases that's been before us, sort of long and tortured history, to put it mildly, but actually was a rent administrator approval of a capital improvement petition. And that the commission actually did reverse and say it should have been for a lower amount than was originally approved. I don't know that that's a good example case because of the up and back remands that have happened over the years in it, but it is one example of where that can happen, and recently.
Those are all the questions I have for you today. I want to thank you all for your work, for being with us today, and we're looking forward to continuing to work with you.
Thank you.
Thank you so much. Before we move to our final government witness, which is the chief tenant advocate, we have several public witnesses who have signed up to testify about OTA. I think some are with us virtually. I'm not entirely sure everyone who is here. So let me call all the names. Brandon Dean, David Marlin with the Committee of 100 on the Federal City, Cheryl Barnes with Chevy Chase Voice 501c4, Rob Lardo, co-chair of DC Tenants Advocacy Coalition, or TENAC. Shamoya Washington, public witness. Fadi Masoud, public witness. Skylar Cordova, public witness. So if any of these folks are in the chamber, please come to the table here. Folks who are with us virtually, my team is getting you queued up and we will start with you momentarily. David Marlin, welcome. You can begin your testimony. And you may have to unmute.
Chairman White, let me begin by telling you how happy I am and how pleased the Committee of 100 is that you've become chairman of the Housing Committee of the Council. Your experiences working with Eleanor Holmes Norton and Carl Racine could not be better preparation, and I've followed your progress, as you may remember. My name is David Marlin. I'm testifying on behalf of the Committee of 100 to provide our support for the Office of Tenant Advocacy, one of the jewels of the district government. In our written testimony, we complimented OTA's leadership and noted that last July, OTA completed a demonstration database mandated by the council in 2015 and sent it to the Department of Housing and Community Development so that DHCD could complete this important resource and make it available to all. Sadly, the database is not yet available from DHCD. That database will provide tenants and the rental housing community with a user-friendly internet searchable research tool for all documents that housing providers are required to submit to the rent administrator's office. Chairman White, we've asked that you use your influence to assist DCA to complete this important project. We also took this opportunity today to urge the committee to address needed and well-documented improvements in the rent control statute. In November 2020, then Council Member Chairman Anita Bonds conducted a marathon hearing and dozens of tenants testified, as did housing providers, OTA, DCRA, the Legal Aid Society, and others. But Mrs. Bond's committee did not produce any statutory amendments to the rent control statute, so no reforms were enacted. Let me mention two provisions that need to be repealed outright. And there are two pending bills that would accomplish that. One by Councilmember Bonds to repeal voluntary agreements, and the other by Councilmember Christina Henderson to repeal certificates of assurance. Both these legislative items have been subjected to repeated moratoria. It's a well-supported fact that the district needs more affordable housing to prevent displacement of our working force. This issue led to the enactment of rent stabilization in the 1980s. I served on the newly created Rental Housing Commission as an appointee of Mayor Marion Barry from 1981 to 85. The 1985 rent control statute, which is the basic text today as amended, contains a provision that has been a poison pill. It's the certificates of assurance. It's been a poison pill for expansion of rent control, as it would hammer the district's coffers, its income, its ability to pay unacceptably. And unless this provision is repealed or voided by a court decision, expansion to buildings constructed since 1975 cannot be legislated. As to voluntary agreements, this provision intended as an alternative way for landlords and 70% of tenants to reach agreement to improve housing services and facilities has produced controversy over the years. The Office of Tenant Advocacy, dozens of tenants, and the Committee of 100 have urged its deletion from the rent control statute. It has not produced the benefits intended, but has been abused. And I could expand on that if you care to ask me any questions, but I'm going to end my testimony now. Thank you.
Thank you very much. Cheryl Barnes, welcome. You can begin your testimony.
Good afternoon. I'm Cheryl Barnes, speaking to you on behalf of Chevy Chase Voice, a 501c4 nonprofit with over 1,300 Chevy Chase DC supporters that I co-founded last year to give residents a voice in issues facing our community. Increasing rental costs and tenant hardships in DC are making the daily news in our city. The loud and persistent tabloid answer is to increase density as a solution to housing affordability and tenant issues. It's a catchphrase that everyone knows in DC. There's currently upzoning proposed for Connecticut Avenue from Calvert Street to the Maryland border, ostensibly to fulfill housing goals set forth in the Comprehensive Plan and Rock Creek West Plan, both of which rely on obsolete data. As CCB has pointed out in other forums, the housing goals proposed in the Equity Report Creating Goals for Areas of Our City, October 2019, are based on estimates that projected a population boom and rely on obsolete 2010 data, census data. The quotas assigned for housing in each ward by the Housing Equity Report are based on incorrect projected population numbers for 2025, which overstate the number of incoming residents by about 100,000. DC has not regained its pre-COVID population levels. The McKinsey Report 2021 concluded that upzoning and increasing density in urban areas accelerated gentrification and reduced naturally occurring affordable housing. And now that the DC COVID moratorium on evictions has expired, DC renters are experiencing increased distress and eviction from their homes. But I'm not here to rehash the deficiencies of various plans. Rather, I'd like to address the proposed upzoning of Connecticut Avenue that will do little or nothing to provide more affordable housing in Rock Creek West and may subtract from available stock. Upper Connecticut Avenue is the heart and soul of Chevy Chase community, and many, probably most, of the Ward 3-4G residents moved to the neighborhood for its small town, slower pace appeal. However, some in our city claim that the area has not done its share to provide affordable housing called for in the aforementioned flawed plans. I beg to differ. Chevy Chase DC has the lowest rents in all of Ward 3, and in fact, are certainly much lower than the wards downtown that have been upzoned and lost all naturally occurring affordable housing over the last few decades. Ward 3 has the largest number of rent-controlled units than any ward in the district, 13,674. Ward 3 is home to 1,366 housing voucher recipients. These residents benefit from affordable housing programs, and these units should be counted in assessing the needs to fulfill the affordable housing goals. Ward 3 has 268 IZ units in the construction pipeline, and with all the other existing affordable housing units, the combined total is 3,171, 711 more units than Rock Creek West goal. Remember, that goal was based on inaccurate predictions of DC population growth. Chevy Chase Voice sees a housing management crisis that has created a housing crisis. In fiscal year 2023, the DC Housing Authority failed to distribute 4,500 federal housing vouchers to DC residents who were requesting housing assistance. Those applicants need and deserve a hand up. Ward 3 has many vacant housing units, as do all other wards in DC. Many DC residents who need housing assistance could be adequately housed in safe and sanitary housing at this very moment. It's disingenuous to point a finger at Ward 3 and say that people are without housing in this city because more housing is needed in this ward or any other ward, when there are plenty of available housing already built in Ward 3 and elsewhere, currently vacant, waiting, and ready. Chevy Chase Voice strongly urges DCHA to assign the 4,500 federal housing vouchers now and to provide full wraparound social services to the recipients who need them so that they're able to thrive in their new homes. How can tenant advocacy possibly advocate successfully for DC tenants when the long-promised database is still unavailable and existing data upon which plans have been executed are incorrect or obsolete or both? Upzoning Upper Connecticut Avenue would create unwanted density, the loss of the only public park in this particular Ward 3 neighborhood, stress infrastructure, sorely tax already overcrowded school resources, and it would inevitably destabilize one of DC's most stable tax bases. We at Chevy Chase Voice hope the mayor and Office of Planning will take a step back and reconsider the plan to increase density on Connecticut Avenue. We don't think our city government understands the adverse consequences of the proposed upzoning. We fear that the mayor and those in charge of her administration are relying on the usual developer promises about cash windfalls from increased density and engaging street walls. In this particular imagined, the gold is a mirage. Thank you. Cheryl Barnes, Chevy Chase Voice.
Thank you so much. And Rob Lairdo with TENAC.
Thank you. Thank you, Councilmember White, for the opportunity to testify today. I'm co-chair of TENAC, the DC Tenants Advocacy Coalition. We advocate for tenants citywide to promote rent control, tenants' rights, and affordable housing. In terms of oversight, OTA has done an excellent job. Tenants need OTA. Tenants have recounted the superb work that OTA's legal, education, administrative, and other staff have rendered in cases of settled law and other matters of tenant advocacy. OTA deserves high marks. We are pleased with OTA's accomplishments over the years. However, even with A students, there is a need for improvement. More specifically, TENAC has long wanted an addition to the OTA website that would list current issues tenants face and the reforms necessary to consider to resolve these issues. This has been informally discussed that OTA provides summaries on the OTA website of current issues needing reform, especially the many problems and concerns tenants have faced. For example, a summary of the issue involving the plus 2% yearly increases, the history of its adoption, and the effect of plus 2% increases on rents since its enactment. Okay, tenant issues and concerns and potential reforms easily accessible from the site could be available to tenants, advocates, and council members alike. Armed with the knowledge of the problems, concerns, and reforms proposed to remedy them, council members can make fair and balanced laws and informed decisions. Which reforms should be added to the site could be decided by OTA soliciting advocates, tenants, tenant lawyers, and the public through various means. These could include surveys, listening sessions, and suggestions from advocates and concerned parties. Then, with such a resource on the OTA website, all stakeholders, the council and their staff, could be brought up to speed quickly on tenant legislation, concerns, issues, and needed reforms. When questions arise among staffers, council members, or in hearings, topics could be referred to on the OTA website and accessed at fingertip from that site. While these issues can be controversial in nature and involve policy decisions, it is also vitally important tenants be well informed of the issues, concerns, and problems that affect the community and potential reforms or remedies for those. We hope that advocates and tenants can work with OTA for a means of approach on these suggestions and also for discussion concerning which issues are important for this addition to the OTA website if adopted. Now, for example, there are current issues and reforms that we have suggested and other advocates we've talked to about. For example, an internet-based inspection system where initial inspection reports are emailed on the spot immediately after any inspection to prevent errors, fraud, and abuse, things like that. A limit on rent payments paid into the court registry when rent amounts are in dispute so tenants do not lose cases simply because they lack financial resources. Things like this, a repair and deduct law similar to the one Massachusetts has. For landlords who will refuse to make repairs, tenants can just have the repairs made and deduct it from their rent. And I understand this law has been successful in Massachusetts. Thank you very much, Councilmember White.
Thank you very much to our public witnesses. And I don't have many questions. The testimonies were clear and self-explanatory. Rob Lairdo, there were some recommendations there for the chief tenant advocate. Some of those are part of some of the questions I have. Others I will let the chief tenant advocate respond to and think through. David Marlin and I think Cheryl Barnes both raised the rental housing database. I think we are getting close. I have my fingers crossed and I'm knocking on wood as I say that. But DHCD is now working with the OCFO for a reprogramming approval that will allow the vendor to complete the project. So we're hoping to have the first rollout phase for small landlords available in the database in May or June of this year, and large landlords later this summer. So we will all keep our fingers crossed because this issue has been rolling for a while. Quick question, David Marlin, on voluntary agreements, since you mentioned that. I share the concerns you raised. But one of my biggest concerns with voluntary agreements, people who support it will say this is a way to get improvements done. My biggest concern is that current tenants can essentially hurt future tenants. And that doesn't seem fair. David Marlin, would you see voluntary agreements any differently if current tenants could not bind or impact the rent of future tenants? You're on mute if you're responding. All right, David Marlin, I see you there, but I can't hear you.
Okay, I've now
There we
I've unmuted. I was really resistant to the idea of changing or deleting voluntary agreements because it was a very good idea when it first came into being. It was intended to provide a way for landlords and 70% of tenants to reach agreements on improving services and facilities, but it's proved controversial for the very reason, Chairman White, that you've put your finger on, because it was used by landlords to agree with current tenants to raise rents of future tenants, and that has turned the intent of the statute totally around. So it's been many years now that OTA, for example, has urged the Housing Committee to introduce to get rid of voluntary agreements. And I don't see any reason why that isn't a good idea, because it's been abused, or to amend the statute as you suggested so that it wouldn't apply to future tenants.
I appreciate that. Cheryl Barnes, I thank you for your testimony. I do understand the point you're making. One thing I just do want to mention, because it is a concern I hear a lot in parts of Ward 3, and that is the need for wraparound social services for many people, including some folks who have housing vouchers. That is something I'm actively working on. So I am hoping we're going to have the beginnings of a solution there, but we certainly cannot have vouchers place people into apartments and in communities and not give them the wraparound services they need to live in harmony with the community. So I hear you there, and I am really sensitive to what's happening and eager to find a permanent solution. So we will keep you posted on that, but we are working on that actively. I want to thank our public witnesses for being with us today, for sharing your testimonies. And we are going to now move to our final, third and fourth and final government witness, Chief Tenant Advocate Shreve. Thank you all for being with us. As you know by now, it's the last set of government witnesses. We are going to swear in our government witnesses, so I would ask that you raise your right hand. Do you swear or affirm under penalty of perjury that the testimony you are about to provide to the Committee on Housing is the truth, the whole truth, and nothing but the truth? Thank you so much. You can begin your testimony when you are ready, and I know that there's a slide that's going up as well. Here we are.
Thank you. A little show and tell for you today. Before I start, please let me introduce the expert team that I have with me today. It's very important, I believe, that the committee know that the work of the Office of the Tenant Advocate is not done in a singular vein, but with the sum of many, many parts. And to my left, sitting with us, is Joey Trimboli, who has been with us for about 5 years, transitioning from the Housing Committee to the Office of the Tenant Advocate. He's our legislative counsel. Next to him is the expert policy counsel, Mr. Joel Cohen, who has been with me for 15 years. And to my right is my esteemed supervisory attorney and former contract administrator of the rent control database. So I brought the team in order to answer all questions that you may have of this particular agency, and then myself, Johanna Shreve, who has been the inspiration, visionary, and founder of the Office of the Tenant Advocate since 2006. And we come up on our 18th year in 2 months. It used to be that I talked about the infancy of the group, and my God, time has flown since we started this engagement. So thank you again, council member, for having me, you and members of the committee and your staff. I want to, again, thank you for the opportunity to testify before you regarding the performance of the Office of the Tenant Advocate during fiscal years 23 and to date in 24. I am Johanna Shreve, the District of Columbia's Chief Tenant Advocate and the Director of the Office of the Tenant Advocate. In April, as I indicated, the office will celebrate its 18th year of existence. And as the agency reaches its level of maturity, I want to begin with a few words about its conceptual beginnings and our working philosophy. Established in 2006, the OTA is the product of decades of advocacy for an agency within the district government to serve as a voice for the tenant community. The need for this agency is rooted in the historical imbalance of economic power between landlords and tenants, as reflected in tenants' relative lack of information, affordable representation, and access to policymakers. That is why the agency's founding father, Councilmember Jim Graham, insisted that the agency be headed not by a chief tenant ombudsman, not by a chief tenant liaison, but rather by a chief tenant advocate. More recently, Councilmember Che referred to the role as that of gladiator. Leveling such imbalances means striking appropriate balances between competing public policy objectives, not simply seesawing towards an opposite imbalance. For example, a viable tenant rent stabilization program must achieve affordability for moderate and middle income tenants while also ensuring reasonable profitability for landlords. Thus, the agency's methodology must be to ascertain as many perspectives and as much available data as possible, which is why we consult with a wide range of tenant advocates and engage in frank dialogue with those who oppose our efforts. This is how the OTA can best promote the interests and the well-being of the renter community as a whole. In our policy branch, this past year, the OTA policy branch continued to promote the interests of district residents in the legislative, regulatory, and judicial branches of district government. Rental application and other fees. The OTA worked closely with the committee and fellow tenant advocates on amendments to improve upon the prior fairness in renting measures. These efforts resulted in a comprehensive definition of the term rental application fee, which for some has represented a barrier to rental housing. By ensuring that the same cap covers all fees that a rental applicant can be charged prior to the execution of a lease. Other OTA recommendations incorporated into the legislation included limitations on roommate replacement fees, a prohibition on excessive cleaning fees where a departing tenant returns the unit in a reasonable condition, and the elimination of duplicative application fees where a tenant applies to multiple units within the same building or portfolio. The OTA also consulted council offices during the drafting of legislation for what became the Rent Stabilized Housing Inflation Protection Emergency Temporary Amendment Acts of 2023, which I thank you, Chairperson White, for introducing. This critical legislation mitigated the impact of historically high inflation on rent increases for tenants who live in rent control units and will continue to protect tenants during the next rent control year, which starts on May 1st. Reasonable voucher rents for rent control. The OTA also contributed to the drafting of the Rent Stabilized Housing Protection Amendment Act of 23, introduced by Councilmember Furman. If enacted, this legislation would help end the district's practice of overpaying subsidies to housing providers whose lease rent-controlled units to voucher holders, thus creating an incentive for landlords to exploit the subsidy exemption and disfavor rental applicants who seek rent-stabilized housing. The agency is monitoring relevant HUD investigations and continues to consult with Councilmember Furman and the committee on this matter. Our regulatory advocacy, the PM tag. During the Property Maintenance Technical Advisory Group's meetings in their most recent cycle of 22 to 23, the OTA successfully advocated to preserve important tenant protection provisions in the Property Maintenance Codes, including existing limitations on the landlord's ability to charge tenants for pest extermination services and the existing tenant right to install smoke alarms where the landlord has failed to do so and deduct the cost from the rent. Rent reasonableness. The agency submitted comments on the DC Housing Authority's 2023 second emergency and proposed rulemaking regarding the administration of the Housing Choice Voucher Program. Specifically, the OTA urged DCHA to reevaluate the reasonable rent for a unit on a periodic basis rather than only when the lease is initially executed or renewed or where the landlord requests a rent increase. The purpose of this recommendation is to close a loophole whereby the landlord can escape rent reasonableness requirements for units subject to month-to-month tenancies by simply never requesting rent increases. Judicial advocacy. The policy branch also regularly weighs in on statutory and regulatory matters that are pending before the courts and administrative bodies. Currently, the agency is monitoring a case at the Office of Administrative Hearings involving a novel statute of limitations issue. In an interlocutory appeal, the Rental Housing Commission's order was consistent with the position that OTA staked out in an amicus brief. A landlord should not benefit from the statute of limitations after failing to provide the tenant with a copy of the unit's 3-year rent increase history, an important disclosure requirement that the very purpose of which is to ferret out unlawful rent increases. Going forward, the policy branch will be looking at the Tenant Bill of Rights. In our experience, tenants rely heavily on the Tenant Bill of Rights for their understanding of the district's rental housing laws. Having postponed the project during the pandemic when wide-ranging emergency and temporary tenant protections prevailed, the agency is once again in the process of updating this document to reflect important changes in the law since original publication. Such changes include the TOPA exemption for single-family homes, new tenant screening laws, and others. Utility cost and submetering. Regarding utility cost and submetering, the agency is dealing with both critical legal and policy issues. As a policy matter, the OTA is once again being asked whether residential submetering should be allowed in the district. In short, the agency's position is that landlords should not be allowed to shift to tenants high utility costs associated with outdated energy inefficient appliances and building systems. Such cost factors are squarely within the control of landlords, not tenants. The district has prohibited residential submetering since the early 20th century for good reasons. Thus, at the very least, the district needs to maintain the incentive for housing providers to do whatever they can to reduce both energy consumption and utility costs before asking tenants to do so. A related policy issue is the lack of billing transparency, where tenants are forced to pay additional fees that may significantly vary from month to month without any explanation as to how they are calculated. Another is tenants having to deal with water shutoffs, where the landlord is at fault for failing to pay the water bill, yet tenants have no access to the water bill or sufficient advance notice of the problem. At the same time, as a purely legal matter, I'll note that the agency is discussing with other tenant attorneys instances of unlawful electrical and natural gas submetering that are now occurring within the district. Ongoing policy priorities. Last fall, the OTA shared with the committee the agency's current legislative priority list, which the agency is reviewing with staff. Among them are a variety of residential lease reforms, protections to provide tenants with a smooth transition when they are displaced from their units under emergency situations, and continued rent control policy reform recommendations. The agency very much appreciates the committee's engagement on these matters and looks forward to continuing these conversations. I now move to our legal branch. The legal branch advised, assisted, and represented tenants in 8,473 intake cases in FY23. In the first quarter of FY24, the agency has handled 1,894 intake requests. The branch also secured cost savings and settlements on behalf of our clients totaling $363,370.23 and to date $13,100. The agency provides legal advice to any district renter seeking such advice and may request may represent a tenant upon request, generally on the basis of a limited scope of agreement. The branch also operates the statutorily mandated online tenant hotline referred to as Ask the Director. Looking ahead, while I want to acknowledge the district's current budget crunch, I also want to note that a continuing agency priority is to build the legal branch's capacity to meaningfully pursue its statutory mission to litigate in the public interest. To fully realize that statutory role, the OTA will need to expand the number of its full-time attorneys. Our education and outreach branch. In FY23, the E&O connected with 7,532 tenants and others at a total of 321 events. In FY24 to date, they have connected with 2,967 tenants and a total of 132 events. Since developing the framework for our current 4-person team 3 years ago, E&O has continually increased the number of tenant classes and trainings, as well as the number of community events attended. The Tenant Association Peer Mentorship Program has grown significantly. Tenants and tenant associations are eager to join the program. Most importantly, at the quarterly meetings, the participating tenant associations engage in thoughtful and constructive dialogue that allows them to share their experiences and challenges. E&O has also executed memorandums of understanding and otherwise collaborated with a number of nonprofit organizations that provide services and assistance to the tenant community. And looking ahead, they will continue to reach ever further into underserved communities as reflected in our most recent communication strategy. 41% of the OTA's ward-specific events in FY23 were in Ward 7 and 8, and 39% of ward-specific events in 24 to date have been in Ward 7 and 8. Our administrative branch, in addition to developing, implementing, and monitoring the agency's budget, is ensuring that all bills are paid and reconciled, ensuring that personnel matters are addressed in a timely manner and according to district policy, and ensuring compliance with the district's certified business enterprise program. In addition to that, they're responsible for 4 key activities. The first one is the Emergency Housing Assistance Program, which we established over a decade ago. And in FY23, we assisted 301 families at a cost of $757,285. And to date, in 24, we have assisted 92 families at a cost of $232,696. It should be noted that an alarming number of our cases in recent years resulted from DOB closings, Department of Building closures rather than fires. The agency is concerned about the frequency of building closures due to housing code and property maintenance code violations that render buildings uninhabitable. The agency hopes to get relevant information from DOB, which could be used to help better target the district's preservation efforts. Our second activity is that we receive data from the U.S. Marshal's Office, and we publish it on our website on a weekly basis. This allows legal service providers and community organizations to intervene on behalf of affected residents and hopefully avert evictions. The charts found at the end of my testimony reflect the eviction data of FY23 and 24 to date, including a breakdown of the numbers by ward. Oh, yeah. Is it here? Here. In FY23, there were 1,668 evictions that were executed out of 1,173 that were scheduled. And to date, we've had 309 evictions out of 549 that were scheduled. The third thing that we deal with is a MOU that we have with the DC Superior Court to provide remote hearing facilities in our conference room for tenants who are before the landlord-tenant court in an eviction case. Tenants who utilize this space also have the opportunity to consult with one of our attorneys on site if needed. And finally, the OTA is responsible for receiving copies of any housing provider notice of intent to sell a single-family dwelling. The OTA reviews each notice upon receipt for legal sufficiency and notifies the Department of Housing and Community Development for further actions when problems are identified. Upon receipt of the legally sufficient notice, the agency sends a rapid response letter to impacted tenants alerting them of their rights and to the availability of OTA legal services. The OTA also sends rapid response letters to tenants who have, 1, received TOPA notices in larger buildings, 2, have been scheduled for an eviction, or 3, have an impact by a filing of a rent control housing provider petition. Going forward in the administrative branch, we are focusing on systematically identifying housing providers who should be deemed liable for OTA's emergency housing expenditures due to housing conditions that result in tenant displacements. Our hope is that the agency's collaboration with DOB, as mentioned above, will aid us in making that determination. I note that a voluntary reimbursement case is now pending, our first one ever. A continuing agency-wide priority in 24 is to help tenants in rent-control properties understand how the inflation protection legislation impacts their respective maximum rent increases. Never before have the caps involved a cumulative multi-year cap in addition to an annual cap, or 2 different caps that apply to the same category of tenants depending on the timing of the previous year's rent increase. For both 23 and 24, the agency's policy, legal, and E&O branches have engaged one another on how to best to present a fairly complicated law to our staff, the community, and our clients. Last week, the agency published on its website a set of explanatory material along with a Microsoft Excel spreadsheet calculator that obviates the need to understand the math. And today we intend to show you that particular website update on the website. So if we can, please, let us bring it to you. You will see for the first time, council member, that now a tenant can go to our website, put in their rent increase, and it will tell them whether or not it is correct or not. This is the first time it's ever been done, a product that didn't cost the district a dime, but because of these 3 gentlemen, we were able to produce this product, and it's right there for you. So if you go and we are telling what to do.
The document is meant to be very self-explanatory. The rows 4, 5, 6, and 7 include the instructions. Just for simplicity's sake, where you have the cursor, if we're dealing with a tenant who is an elderly tenant or a tenant with a disability, they would simply enter their current rent in that space right there. So let's say you enter $1,000 in that space. Right there and hit enter, it automatically calculates your 2.9% increase. So at that point, you would know if your increase was more than $29, there's a problem. The most complicated calculation is included in rows 19 through 27 and a little bit below that. And that's in scenarios where there was a rent increase between May 1st, 2023 and June 30th, 2023. And we can give you an example there. Let's say your rent was $1,000 prior to that increase, and it was increased to $1,050. At that point, we know this automatically calculates the rent increase at that time, which was $50 and 5%. And it tells you your maximum allowable rent increase will be $51.45, which is 4.9%. If let's say that the increase was actually to $1,100. So in that scenario, obviously it's a 10% increase. You would only be able to get the difference between that 12%. And if you'd enter 1,100 in the second box, yes. In that case, your maximum rent increase is only 1.8% or $20. And the lowest section is, if you continue scrolling down, thank you, is if neither of those apply to you, then your maximum rent increase is 4.9%.
That concludes my testimony, sir.
That's a good way to conclude it. Thank you very much. Councilmember Fruman, who is a member of this committee, has a 5 o'clock meeting, so I'm going to let him jump in with the first round of questions. He's joining us virtually. Welcome, Councilmember Fruman.
Thank you very much, Chairman White, and thank you, Chief Tenant Advocate Shreve. That was a great demonstration of the calculator. We will definitely be pointing people to it as they call us and ask us questions. I want to ask a little bit about people calling and asking questions or seeking help. The number of intake episodes that you have on the order of 500 a month, I believe. Maybe it's even higher.
Yes.
Can you talk to me about what happens with those? And
The process.
Yeah, the process. But who is trying to help those people? Is it attorneys? Is it paralegals? Is it caseworkers? I mean, I would think that if there's 500 a month, my experience when people reach out to our office about landlord-tenant issues is that's not just one call. There's a lot of communication that follows after that. So the buildup, the enormity of that intake seems striking to me. And I'm curious how you manage it and whether you have the resources to manage it in the way that you would hope to.
Well, I'm gonna answer it in two ways. One, that's why I have the supervisory attorney with me today. I knew we would probably get some questions along this line, but the first one is I've asked the council over the last 3 years to give me funding to update our intake system. We do have an intake system. So every call that we receive, whether it's after hours or during the hours, is held into our intake system. So if you call our office, we know you've called. Once you have called, your call is taken in by our front office team, which we have 2 staff individuals that run the front office. And once that call comes in and the information you give us as a tenant as to what your complaint is, it is then rotated to our legal branch. And like I said, the supervisory attorney who has been with me for 14 years is here to talk about that today, because we really want everybody to understand how our system works. So I'm going to let Amir Sadeghi answer that question for you now.
Thank you.
Council member, there are 2 ways in which the primary intakes are received by OTA. One is through the Ask the Director portal on our website, and the second is through our general front desk reception. The Ask the Director portal is manned by an attorney and a paralegal. Once they receive the written questions, they then formulate written responses. The responses are vetted and reviewed and then sent out to the tenants. Through our standard, and the majority of our cases come through our standard front desk reception. In that scenario, the front desk receptionist will assign the case either to a case management specialist or to an attorney advisor based on the complexity of the case, based on what that person has asked for at the time. So cases that are less complex, maybe the tenant's asking about a housing conditions complaint that's fairly simple to answer, or a security deposit question. Those will initially go to a case management specialist. If they can be resolved in that manner, then the intake will be closed. If there's a need for escalation, then they'll end up with an attorney advisor, and the attorney advisor will provide whatever advice or representation activity that's necessary.
Do you feel, I mean, we do hear, and you hear about every agency, that, you know, there are people who reach out to OTA and their perception of it is that it turned into a dead end. There are people who reach out to our office, and sometimes I think they would say it turns into a dead end. We're trying very hard. I imagine that you're trying very hard, but the inflow for you is enormous. And do you feel that you have the resources to address that inflow as it stands? Do you feel like you're able to timely respond and then stay on issues where somebody raises something? And often it's not just one call, it requires ongoing follow-up. Do you have the horses to do that?
Let me answer it this way. We are going to be moving soon. And one of the things that we are looking at now is an upgrade to our incoming telephone system. Telephone systems have become quite complex and quite sophisticated, allowing you to do a lot more than we are able to do. I'm looking at whether or not AI will become a part of our life, which I think it will be, because there are some things that you can answer, the AI can answer, that leaves your staff free. We do need more staff. And when I say we need more staff, we need more attorneys, and we do need one more case manager. We lost a case manager, and it makes a difference because there are some things that are routine that the attorneys don't need to address. But there are other things that I see coming into our office where brief representation on the part of the Office of the Tenant Advocate possibly should occur. And we can't because we just have too many cases. And then there are the follow-ups that come behind the cases that the attorneys end up taking on. And when we give you a number, we're not giving you the follow-up. We're giving you what comes in the door. You don't see the second column that says, what was the follow-up to all of those calls that we got? So there's another 3,000 or 4,000 follow-ups that go, so that 8,900 or 9,000 cases now turns into almost 15,000 a year. And that's a lot of work for the small team of people that I have. So I can't emphasize enough the importance of us receiving as much assistance as possible. But I do believe that we will be able to look at the new way of using the telephones and so forth to give us some, I won't say major relief, but to give us some relief, because I think we can use AI in some very productive way.
Mr. Chairman, I wonder if I could just have a couple more minutes and then I'll leave it to you, but just a couple more things in this space, if that's all right.
Certainly.
So one of the things I think, Chief Tenant Advocate Shreve, that you talked about was that you will have a request for an additional attorney. I saw in your responses that there was a reference to a program that existed before where you were able to contract out with other legal services providers and leverage the skill of those people, but that program was defunded. Is that a thing that you think it would be useful to try to reinstate? Would that help take some of the weight off your shoulders? Where do you stand in terms of your desire to see a program like that in place? Because there is a community of attorneys out there who work in this area. So I'm curious your reaction on that.
I would answer by saying that I would like to talk to my legal staff to get their opinion on that. The original legal service provider program, which Jim Graham actually instituted for me, was at the beginning of the reigning of the OTA. We didn't have any attorneys at that time. So those 8 attorneys that I had, and I had some private attorneys too, which was very helpful. It allowed me to have sort of a tentacle into the community. So I had some attorneys who were into the housing authority type of business. I had one attorney that was focused specifically on senior issues. So I had folks that were, spread out. Neighborhood legal services were doing some other kinds of work for me. So we had attorneys that were already ensconced in certain aspects of law that I was able to use them for that particular thing. One of the things that I didn't have, which is very important to me for the OTA, is the public interest side. We need to be able to articulate for the government as a governance body what the public interest is and how that impacts all of the tenants in the district. You see what I'm saying? So there's some things that can be done in the other context, but in reality, from a governance perspective, we still need to have the ability to address policy and governance matters that of impact how you, the city council, make decisions on certain issues. That would be part of my answer.
And I'll take that as a jumping off point to thank you for the work that your office has done in support of efforts that we've been pursuing, and you have been invaluable as a sounding board, as a guide, as we try to figure out how it is that we might try to accomplish shared goals in this space. So really grateful to the extent that your office has the bandwidth to do that, the generosity that you've shown to our office as we've worked on various issues. I'm going to stop in a second, but I'm going to stay on the intakes and try to get your sense, if you will. There are different categories of kinds of issues that are raised in the intakes, but the two biggest ones are housing code violations and lease issues. In housing code violations, and we've had an issue on a building on Connecticut Avenue where the heat didn't work for an extended period of time, has been on and off, very serious kind of housing code issues. And your office has been great in working on them. I'm wondering, are you seeing the seriousness of housing code violations changing? This one strikes me as a big one. As buildings get older, that you get bigger and bigger issues, frankly, that can be housing code violations. I'm curious if you can speak to the nature of them. And then lease issues. One of the things that we are hearing about is one tenant wishing the landlord would enforce the lease against another tenant. And I'm wondering, I don't know what role you play in that, whether you're seeing much of that, where it's not so much that the tenant is accused of a lease violation, but the tenant is invoking the lease as a basis for seeking relief from the landlord. I wonder if you could speak to those two things.
I'll say that on the tenant versus tenant issue is very difficult. Most legal professionals will tell you they walk away from that conversation. It's a no-win, and as an attorney, you already know the answer to that. As it relates to the housing code violations, I'm much more aggressive about that. And I have reached out to Director Brian Hanlon, and I'm developing, I hope, a new relationship with that office to ensure that they get about the business that they should be, and that is dealing with these consistent housing code violations. Two things I will say to the council that I say all the time. I don't know why people don't have replacement reserve accounts. I don't know why we're not demanding that they have preventative maintenance schedules, because when I read about 5521 Colorado that has no heat and it's 39 degrees outside, when I hear about the Ellicott house that has no heat and it's 39 degrees outside, when I hear these things and when I hear that there's no hot water, I am very upset, because I do not believe we should be excusing people who charge rent, who are receiving good money, okay, from the tenant community, but they are not taking care of the business of managing an asset in the professional manner it should be. I've been in this industry for 45 years. I do not accept the kinds of things that I see people writing to the council and to the tenants. I don't accept that. It's unprofessional. It does not have a place in the way we govern the housing stock of this city. And we have too many people who are suffering on a regular basis because these people are not doing their job. Now, either they do it or we put them out of business. We don't need to hear the excuses of housing providers telling us that, oh, we had to call our mechanic and they had to order the part. These are things that they should have been doing in the summertime in preparation for the winter months. It's the same thing with the school system. I don't believe in all that kind of stuff, because buildings are buildings, no matter whether children are in them or whether people housed in them. They should not have to suffer the way we see this going on consistently. And we get the emails. We get the emails every day. Ellicott House, we've had it from Mike, whatever. Mike has written us 3 or 4 times this week about no hot water and no heat. Why?
Well, I'm very glad that you take note of that one in particular, because as you know, my office has tried to be very active on that. I can see why my predecessor referred to you as a gladiator. It seems like that is a role that attracts you, and I'm very glad to have that kind of spirit in place. I will want to pick up the conversation. I do.
Roman, I could do an additional round. I do need to start getting through quite a number of questions.
No, I was on my way out. I was on
Okay.
my way out. I was just gonna say, I will want to pick up the conversation. We started it in the last hearing that you appeared at about preventive maintenance schedules and replacement reserves. But I'll do that a different time, and I will cede the floor back to Chairman White, and thank you very much for your indulgence. And thank you to the witness.
Thank you so much.
I apologize to you, council member. I'm sorry.
No, it was great. Thank you. Talk to
I'm
you later.
sorry.
No, not a problem at all. So how does, we get a lot of housing concerns. You get a lot of housing
Yes, sir.
concerns. How does OTA collect feedback from tenants and stakeholders to inform your priorities or strategies?
Well, as you well know, historically, we have always analyzed the top 5 issues in the city. And unfortunately, those top 5 issues haven't changed in the last, probably in the last 15 years. And that disturbs me. And it's one of the reasons that we are now getting ready to have a conversation with the Department of Buildings, because I think we need to start looking at, we need to look at the conditions of housing in the District of Columbia. And I think that it's important that there needs to be some real thought about proactive inspections and what that really means, how they really do proactive, what are they looking at when they do an inspection? Because we should not have tenants in our city, no matter what their rent payment is, paying rent and not getting the services that they deserve. And we should also be concerned about the condition of some of the properties that we see tenants being placed in. I have to tell you that I'm very concerned about some of the DHS programs and the place that tenants are placed. We get constant information from the tenant community that's driving me a little bit out to the insane side. I don't understand how we're paying for a sister and her children to live into a property where the toilet doesn't work and there are rats and mice in her closets, and she's writing now to the Office of the Tenant Advocate, but her rent is being paid by the Department of Human Services. I'm concerned about who is doing the inspections.
Let me stay on this question though. So with all the concerns that you get, how do you determine the order of priority?
The order of priority of,
You can't handle everything at once.
that's true.
So, how does, one of my understandings is that you're going to reintroduce surveys in an electronic system. Is that right?
Yes.
Do you need additional funding to do that, or is that something that you can get going now?
Well, we need funding to bring Monkey Survey up online, because you have to pay for that. But I would believe that we need some funding. Do we not need some funding, Amir?
Yes, with one of the plans that we're planning to implement, and this actually also goes to the council member's prior question about reducing the load and handling the amount of intakes that we get, is to implement a new electronic intake system. So the intake system would actually, as Ms. Shreve just mentioned, be able to disseminate questionnaires and surveys to the public to get their feedback on how we are serving them and what else we can do to provide additional services to them. But it would also assist us in doing our day-to-day activities more efficiently and be more effective and do more for the tenant community.
Because now, council member, you can someone can call you right now and you can call me and I didn't answer your call, but I can send you a voicemail and say, I just got your call and I will call you back. We can't do that right now. And that's something that I want us to be able to do. I want us to be able to, if you've been seen by one of my attorneys or one of my case managers, I want to be able to send you immediately something that tells me, what did we answer your question? Did we take care of your need right now? Or is there something else? See, those are the things that I think they're immediately It gives you an immediate reaction, an immediate response to the services that you're providing to the
Right.
tenants. And that's where our next step is. And so as we get ready to be moved out of the Reeve Center into the next place, I want to make sure that we have all of those kinds of deliverables at our exposure so that we can do a much, much more sophisticated job of responding to the questions that you have of us on a regular basis.
Do you anticipate that type of sort of survey or interaction that you mentioned going via text message or email or how?
The way it is now is that you can do it as a text message.
Mhm.
That's usually the way you can do it the easiest because it's tied exactly to that number that you've called me on. If you do it by email, the same thing would apply. So you can do it in both venues. You see what I'm saying?
Yeah.
And it's something that's available. It's not like it's new technology. It's here.
I'm gonna get back to this issue of prioritization, but moving, where are you moving to?
Right now, I'm scheduled to move to 899 North Capitol Street, although I've been trying to move somewhere else. I believe that we should be closer to 441 4th Street, which is closer to the courts, closer to the Office of Attorney General, closer to the Office of Administrative Hearings, closer to the organizations that we have the most kinship with. But right now, we are scheduled to move to 899 and I think the latter part of 24.
Okay. How far is that from Metro? I know it's not far, but I don't know how far.
Well, depending on what's happening at Union Station, okay, which is right next door to this location. Union Station is the next big, they're gonna be doing construction there soon. I have a concern about families having to come through construction zones and those sorts of things. In addition to the drive-by shootings that are going on North Capitol Street, I have concerns about my staff safety and I have concerns about people's safety coming to that location. But
What was is there a space at 441 that you know of?
I don't know.
Okay. Do you know how many square feet the new office space is?
We are somewhere around 10,000 and change. I even was willing to give up a little bit of space in order to get us there. I don't know. I don't know.
Let us inquire about that.
Thank you.
So, I one of the reasons I asked about prioritization is because as the housing committee, we get a lot of complaints about housing issues and it's nonstop and you all get more. There are so many people in the city with tenant issues. How does your office prioritize intakes for legal assistance or representation?
The answer to that question, I think, is a little bit more complicated because when a call comes in, when a tenant calls in and says, this is the problem, it's not until they've been transferred to the legal branch and someone actually begins to talk with them that you get to the heart of what the call is about. Because people don't necessarily articulate their issue, if you will, in a form that matters. And so sometimes people write something and I can tell you, I read every day. Most of the ATDs that come in, I read them myself. And so I'm very in tune to what happens on the website. But when it comes to the intake, I would have to defer to my supervisory attorney to sort of answer that for you in terms of how they distinguish what gets taken into what is the representation issues versus what is something that we're just going to talk to you about.
Right.
As Ms. Shreve mentioned, it is a complex process of how to allocate the priority to different the intake issues. One of the first things that we pay attention to is the severity of the issue and the likelihood that it'll cause some physical or other harm to the tenants involved. Just today, I got a call from a tenant who had an issue with heat and electric outages. And once I delved into it further, I realized it was an issue that has already been addressed. So even though it came to us as a housing conditions issue, at this point, all the tenant wanted was financial compensation for what he had gone through. That type of thing, although it is a matter of priority, wouldn't be as highly prioritized as a matter where a tenant doesn't have currently hot water or heat or something of high necessity. So the first thing we do is we assess the harm that could come about immediately as a result of the housing code violation. If it is something that needs to be addressed immediately, we take it on right then and there. After that, it's just a matter of our resources and when are we able to do it. Usually, it's our policy to deal with these matters immediately as they come to us. Somebody calls, it's assigned to somebody, the person calls them back, and if they can deal with it by assisting the tenant in going through the DOB or inspection process or the housing conditions court, they'll do it at that time. And then sometimes it is an ongoing process of multiple calls, follow-ups, and that sort of thing. But that's how we allocate our resources.
What about referrals out to legal aid organizations? How do you make those determination to refer someone out?
Again, there's a lot of complexity to it. What we try to do is we try to take on the matters that we can internally. So if we believe that something can be handled with an interaction with a housing provider, we'll pick up the phone and we'll call the housing provider to attempt to resolve the issue right then and there without getting involved in the legal process. If we think that it's a matter that our resources will allow us to litigate, then we'll initiate litigation, whether that's partial litigation, limited representation, or full litigation. If we get to a point where we realize we're not able to handle this with our limited resources available, then we determine, well, what's the best avenue in which to direct this? So just as an example, we have some partnerships with some law firms that like to take on pro bono cases. So if we think that it is a good fit for that sort of assistance, we'll do that. If we think it's a good fit for OAG because it involves a large number of tenants or something that needs to be litigated more proactively on behalf of a tenant community, we'll reach out to OAG, or as you mentioned, one of the other legal service providers, legal aid, neighborhood legal services, legal counsel for the elderly. It really depends on the type of case.
Okay. Do you get many complaints about prospective tenants facing buildings who are saying either we're only accepting people with housing vouchers or we are not accepting people with housing vouchers? I've heard both of these, but I don't know how frequent it is. I don't know if those types of concerns come to your office.
But I don't really think we've had that experience yet. I mean, I know I've heard of it, but I don't think the Office of the Tenant Advocate has had people calling us. There's been, folks insinuate that the property is only accepting people with vouchers, but we have not had a tenant applicant come to us and say, I was denied the ability to file an application because they're only accepting somebody with vouchers.
Right. Okay.
Have you, Joe?
Well, I think it's anecdotal.
Get on.
Am I on?
Yes.
Right,
Yep.
okay. We certainly get a lot of anecdotal information from tenant association presidents, but particularly at particular buildings with common ownership and management, the rent control buildings along Connecticut Avenue, for instance. So there are sort of associations of these associations who, as you know, and I know Councilmember Fruman knows, are dealing with those, hearing those complaints. I think the policy division probably gets a lot of those complaints, but it's not case by case. It's in the aggregate.
Okay.
Only in the instance when Attorney Racine was still in charge of the office of when he was the Attorney General, where we had a employee come to us about this issue, which resulted in the $10 million settlement and the elimination of the Darrow Realty company. Now, that case, which happened in 22, we were intimately engaged in it because the whistleblower came to us. But the case was so large, then our legal department referred it to the Office of the Attorney General, which resulted in the $10 billion lawsuit settlement. So in that instance, yes, but it wasn't a tenant. It was an employee who actually had evidence regarding the practices of the management company.
And I'll just add that very building that flipped after the lawsuit, and it was the subject of the opposite complaint. Yeah, that there was a refusal to rent to.
Yeah, I mean,
stabilize
yeah,
it.
so the opposite then applied. So we see that as being an issue that needs to be resolved, because you can have on one side, but it actually affects the other side too. I mean, it's a very, very messy situation. And now that the investigative piece from HUD has occurred, the second one regarding the manifestation of false rents. Oh, it's some of the craziest stuff going on right now. That's why we're very much engaged in following this matter. And we work with, going back to the housing code violation side, our staff works very closely with a lot of the inspectors. As an example, if we get a call from a tenant saying, I don't have hot water, we will call the inspection branch and get somebody out to that property ASAP, because that is a true violation. And if that is the case, then there's a closure that occurs, which then triggers the emergency housing program, where we will put the family in a hotel until that problem has been resolved.
Okay. Do you hear of tenants facing retaliation from landlords after reaching out to OTA?
We don't hear, again, it's an inference that is suggested to the Office of the Tenant Advocate. The term retaliation in and of itself is an abstraction. To define how it is used, how people use retaliation. We've had retaliation by landlords in a variety of situations, particularly more so with students than with just the regular tenant bodies. But most of that I account to the failure of the people who have decided to rent their properties. They know nothing about the business. And so their conduct is totally contrary to what you would think, you would see in a housing provider to handle stuff. And usually, and I won't say this in any way, but it's older people that are renting spaces for specific reasons, but they have no idea what they're doing when it comes to managing that property. And a lot of times they don't even have the basic business license. So the thing you get from the tenant, like I had a couple of those just the other day, where relationships began to sour between the tenant and the landlord for reasons. My son needs to put his stuff in the storage downstairs. The woman's been living downstairs in the basement for 8 years. They've had a good relationship, and then the woman downstairs says to the owner, well, but that's where I put my stuff. And the owner then says, but my son's going to put his stuff. So now their relationship starts deteriorating, and they write to the Office of the Tenant Advocate. I'm being retaliated against because when you read it, you go, this is a human problem that's going on. That how do you solve it? There's no law that deals with that.
Do you obviously you all work primarily with tenants, but do you engage in landlord education?
Yes, we do.
What's that?
And we will be doing more of that because there is no tenant ombudsman right now. And there are new regulations that all landlords need to know. And so I asked my staff to put something together for the land. And I don't think there's anything wrong with that. We have to make sure people know the rules of engagement, because if you don't know the rules, you can't play this game. And if you are playing the game, a lot of times it's the wrong way.
There's also a number of realtors who reach out to OTA. So aside from housing providers,
Right.
realtors have a big interest in learning more about landlord tenant laws, and they are large participants in some of our
Well, let me
outreach
tell you.
events.
Yeah, and then listen, our esteemed legal counsel here, legislative counsel, he was the consultant to the real estate commission who just testified before you. We went through the changes for all of the regulations for the update of the tests that they give. We insisted on we didn't insist, we professionally requested that they would allow us to participate, and they did. We wanted to change the test for them, but they had a consultant or something that they were using for that. But we did, in fact, we did manage, we dealt with the test because we knew it was wrong. Not wrong, but it needed an upgrade. Let me use some more professional semantic word, right?
It's
I think it was at our last hearing, we spoke about, the idea, at least my belief, that OTA should give some thought to how it measures improvements in tenant conditions that result from your work. Do you have any further thoughts on that?
Well, you know, we do get feedback from the tenants, particularly in our ATD, our hotline, online hotline program. We get feedback from a lot of the tenants. And last time I think I misspoke, because if I go to my personnel records about all of these gentlemen at this table and all of the other staff that we have, they get high compliments about the work that they've done for tenants. Again, I believe it's a change in the manner by which we start looking at the results of our performance, council member. And that's why I said the new way of being able to instantaneously get a feedback from a tenant when we've helped you to find out, you know, once we finish giving you that advice or recommendation or helping you draft something, that you're receiving something from me, either in a text or on a voicemail, saying, can you tell us on 1 to 5? Because if you look at the way the world is today, I don't care what you do, you get 5 stars. Which one am I? There's always a feedback that people are asking from us every day, no matter what we do. And so I think it's a matter of us adding that sort of performance return, so that in answering questions both to our legislative bodies, that we're saying to ourselves, we did a good job there. Or the supervisors can say, my staff is doing a good job because I can look at the responses I'm receiving from the feedback that we get on this new way of getting information.
I guess what I'm asking here is by the time somebody comes to you for help, you have to sort of triage an existing issue. Are there ways we can measure permanent or more widespread improvements that are preventing some of those emergencies from happening?
Are there permanent or widespread means by which we can help to prevent in the future that same situation occurring?
Right. So I think the city is better off if you're getting fewer complaints. So we could measure sort of the number of complaints you get, the number of people you help. We could also measure improvements that are preventing some of these complaints from happening in the first place.
Well, okay, let me see if I understand. If the Department of Buildings use their name of that fund, the nuisance abatement fund, more frequently to do more than sweep the streets, and they went in and they made a decision on the financial level at which nuisance abatement dollars could be used to, let's say, replace hot water heaters when you got no hot water. Then that's a way for us to measure the results of performance, because herein lies a way to correct the remedy and to correct the problem going forward so it doesn't happen again. I think it's one of the things that I'm trying to look at in terms of the closures. I want to know, why are these buildings closing?
Mhm.
Why are the buildings closing? Maybe in answer to your question, once I get a handle on the 238 buildings that closed in the last 2 fiscal years, I want to see what the commonalities for those closures are. Why did those buildings close? The other question that I have with regards to that is how many of those buildings that were closed actually have been reopened? Because the problem that we see is that you have tenants who have lost their place of residency.
Right.
Where did those tenants go? And we don't really have anything to do with that because our job is to provide the temporary housing. But until I'm looking at that because I also sat on that task force for preservation of housing. And I want to know why we can't preserve this housing, put covenants on those buildings to extend affordability without us having to build new ground up. So there's a way for me to look at some of these things in a different context, but right now I don't have the tool set, the toolkit to do that because I don't know enough about what's causing the problems that the tenants have. When a tenant tells me that they have mice and they have this, that, and the other, I don't have control over the environment to correct that. Do you understand what I'm saying?
Yes.
You can call me, you can call my office and tell us this is the problem. I can say, have you talked to the Department of Buildings? If the tenant says, yes, I've talked to the Department of Buildings, the problem still has not been resolved. I am not in control of a toolkit to fix that problem.
Right. That's one of the reasons I keep asking, we'll keep trying to find out, the frequency of specific complaints so that we can look at what those commonalities are. The council may be able to solve some of those or have other agencies step in. I'm wondering if there are data that would help us prevent some of the issues that are the more frequent issues that you're being called about.
Well, if you call me about mice, the law will not allow you, the council, to fix it unless you change the law, which says that you will now allow the government to go in and provide extermination services or the services necessary to eliminate the mice, because as it stands now, the government will only deal with that problem from the exterior. You will not touch that problem on the interior.
Right, but we don't even get to the point of thinking
Knowing that is the problem.
solutions, unless we know, the top 3, 4 issues that your office is being called about.
Well, we can tell you, well, one of the things that the change in our data gathering will do is that it will allow us now to more categorize what do we mean by housing issues? Housing issues is too much of a broad, and Amir will tell you, that's where I'm from. Housing issues is not what I'm looking for. I want to know what inside of housing issues are the problem. Is it no water? Is it, what are the things that are causing that tenant family to be unhappy and not be able to live in an environment that you and I live in? We want to know what that is so that we fix that problem. And right now, you see, when we created the system initially, we created it with the broader ties. Now we have to go back and now we have to do what we did with the database. You have to go back and now you have to put in new algorithms so that you can collect that data. Right now, we haven't been able to collect the data that I can answer your question. That would tell me to tell you, here are the top 5 things inside of housing issues, not housing issues, but the 5 algorithms inside of that. These are the things that we saw the complaints at this year.
Yeah, I really, I'm eager to start solving some of these upstream issues.
Understand.
I think I asked you this before and I can't remember the answer, and I should know it. But do you track complaints by building and management company? So could we tell from any data that you have, we have an overwhelming number of
No, not
complaints?
now, you can't. It's another algorithm I don't have, but it's one that let me say this, in terms of the work that I'm doing with the Department of Buildings, I am going to be able to track it by building and owner.
Okay.
Now, maybe they also have management companies, but DOB has a lot of information.
Right.
So they may be able to, on these 238 closures that I'm using as my basis, my control basis, I should be able to ask that because it's on the list of the report that I want them to give me from analysis. I want to know who the owner is, when the building was built, who's managing the building, and why was it closed? And once I get that information, what were the things that closed it? Because on the placard that they told me that they put on the building, they cite the building code reason for closure. So I'm going to know what closed the building. So did these buildings close because of electrical work? Did they close because of plumbing work? What is it that closed it? Because the abatement was never done.
Right.
And so we have, those things are the things that I'm trying to gather at. So we can look at, can we go to the preservation dollars that are over at DHCD, take those dollars? If we say $250,000 as an example is the maximum amount we will use to correct the problems in a building to bring it back to life, how many buildings can we bring back to life for $250,000?
Mm-hmm. So since you mentioned abatement, one of the concerns we grapple with is how to determine whether abatements were done well.
They can't be done virtually, I can tell you that.
I think that's right. And you know, we can't just take the building owner's word for it.
Right.
There are a lot of abatements being done. Do we need to have DC government employees checking every single one?
Yes. Yes, you do. Why don't you give them another 8 or 9 inspectors, and that's all they do. They do the abatements because, you see, there's another law that says if you have a violation and you didn't fix the violation and we, the building department, has to come back out here, it's going to cost you $90 for every unit that we have to come back. Guess what? They don't collect that $90. If they collected the $90, they could pay for some of these people. I've been dealing with this for the past 15 years. Joel will tell you, I've been dealing with this. I've been asking, why haven't they been collecting the $90 on re-inspection for going back out to that property when that dude has not fixed that unit?
May I just comment on that for a second? You mentioned previously about building-wide complaints. I just wanted to note that the Rent Control Clearinghouse database will have a functionality that allows you to actually review those complaints by accommodation or by building if there is collaboration with the Department of Buildings. That's one thing.
So if I'm thinking about, I'm sorry to interrupt you, if I'm looking at a prospective building and I'm thinking about renting a unit there, I could be able to see the complaints for that building.
Yes. Now, here's the thing. As the person who for several years was
The contract
heading
administrator.
heading this database project, you know, I had this somewhat larger dream of having a connected city, right? So you just mentioned, well, do we have to send another inspector out to take a look at the work that's been done? Ideally, you may not have to. So in an ideal world, you may be able to have an app or a website where the tenant submits a complaint. The complaint is then forwarded to both the Department of Building and the housing provider. If the housing provider remedies the complaint in a sufficient amount of time, the housing provider can then send a response saying this has been addressed, and the tenant, him or herself, can then confirm or deny that. So a lot of these issues could be done in a way that saves government funding or government expense. But even in a scenario where an inspection has already been done, there is a deadline by which a housing provider has to remedy the issue. If the housing provider has done so, again, the housing provider can go on the app or the website and just say, I completed the repairs, and the tenant can either confirm or deny that. Now, this obviously doesn't exist at this point, but if we were in a scenario where we decided as a city, well, we're going to collaborate between different agencies and we're going to implement this new system, there is a possibility of doing this in a way that works better for housing providers, tenants, and the city.
But if you have a pinhole leak in your pipe and it is dripping inside of that wall, and that wall is wet, and that housing provider comes in and says, well, okay, you have a problem. We're going to paint over it. That has not fixed the problem.
Yep.
Okay.
That's similar to the example I was going to give.
So,
And which isn't to say it's impossible. So like if
No,
I have
no,
a broken
absolutely.
doorknob, I can look and I can say, so there may have to be categories for.
there's no question, but I think to get started, sometimes you have to be a little bit more comprehensive.
Yeah,
Right now, what we have is not working.
that's right.
It's not working. And so we want the tenants to be thinking that the money that they pay for rent, they're actually getting the product that they're paying for. And in this particular instance, particularly where we have these waterfalls inside of those pipes, and that happens when the pipes are old, we need to make sure that the housing provider understands that government is very astute in these matters. We do not want you thinking that we're so governance heavy that we don't understand when the tenant says they didn't fix the problem, they painted over it.
Mhm.
Because that's happening when you're dealing with mold issues. We see this all the time. We see it all the time. If you go out to the property, it doesn't take it, you just look, you can see, you touch, it's wet. So I think that this is the future. This is the now.
Yeah.
So you have to sort of bridge the gap of how you want us to handle it. We're happy to get engaged. We're happy to be better partners. And now that we think we have a partner at Department of Buildings, I think we'll see some changes.
Yeah.
I did read the report. I read every page of the 31 report that was done by the council's office. And nothing that they said in there was anything that we didn't already know. I mean, we've been dealing with this a long time.
Yeah.
So
Well, I'm optimistic about Director Hanlon as well. But we've got to keep pushing.
exactly.
So you've been canvassing buildings as well, buildings that have housing code violations. What are you finding in that practice?
Well, our staff used to actually go out and do inspections of buildings. We used to actually go, I used to send my staff to,
Pre-inspection.
yeah, we did pre-inspection investigations a lot. And the kinds of things that I'm describing to you, we saw the infestations, the mice infestation, the cockroaches. We see people in properties where they have, the bathrooms are not, installations are incorrect. We see a lot of water usage, waste. We see that a lot. We see cabinets that fall off the walls because they're not being replaced properly by the housing providers. When I did the Kansas Avenue site, this was in 22. I was the OTA staff that worked with the owner on his 12 4-unit properties and inspected those properties and made him do a lot of changes to his properties. So there's a lot of older buildings that need upgrades, council member. It would be helpful if they got the upgrades for the quality of life of the people that they serve.
So this connects to something you mentioned in your testimony. You have proposed to my team mandating replacement reserve funds for landlords to pay for anticipated maintenance costs, which makes a lot of sense to me for new construction. But for existing buildings that are facing financial strain, do you see a way to begin implementing an idea like
Replacement
required,
reserve.
yeah, replacement reserve funds.
Yeah, the notice of replacement reserves, to me, all properties should have it. It's a matter of professionalism in the industry. In existing properties, I still haven't figured out how we as a government can help them to develop the fund, let me put it this way. If you're gonna come in for a rent increase, okay, you would have to, first of all, justify for us why you needed the rent increase. That, because I think the automatic rent increase business needs to be rethought. The automatic adjustment that we do now. If you came in and you had done a replacement reserve analysis of your property, the analysis is going to tell you what you need in order to ensure that the property, you're prepared when the roof needs to be replaced and the appliances need to be, all of that. And it tells you how much money you need to add to your rents to do that. So if you came in for an adjustment, hardship, let's say adjustment, maybe we could create a way so that in the law, we changed it so that we gave you that ability to get that increase over a period of 3 years. So you don't slap the tenant with it this year, but each year you get a little bit more so that you can begin to put that money into a account that you could invest to and build up the reserve that you need to address your replacement needs. Now that's one theory that I have, because I've still been struggling with, and I know I've said this for 15 years, replacement reserves. In new properties, they should already have a replacement reserve account. You would think that that would be something that they did. Any property that is purchased, we could, from a legal standpoint, a governance standpoint, require that you are establishing a replacement reserve account. What that then means is that over time, maybe in 5 years, we could eliminate capital improvement petitions.
Yeah.
Because right now we're charging the tenants for your asset to be taken care of. I don't understand that at all. And I haven't found any place in this country, have I, jurisdiction wise, where the tenants pay for the housing providers' capital improvements, except here. You see. So some kind of way we need to talk about an imbalance, as my opening salvo talked about the power imbalance. That's an imbalance that we're putting on the tenant to pay for the housing provider, not to mention, we haven't talked about submetering yet, which is a whole nother imbalance, but think about it. So there should be a way, if we give you the ability to get an increase, and let's think about the increase. Why is it automatic? Why do you need an increase every year? Usually you need to justify why you need an increase. If we get an increase from Netflix, they give us some gobbledygook about why they're going from $19 to $22. If we get an increase from Verizon, they tell us some gobbledygook about why we're going from $69 to $72 on our wireless. Everybody comes with a rationale. So tell me, why does a housing provider need an increase every year?
I'm not going to justify that.
Well, I know you're not. It's rhetorical to you, but that's my point. The point is, I think the council needs to look at that law and decide, why are you giving an increase every year? HUD had done that. If you go back and look at the HUD history, you'll find out that they ended up coming up with legislation to reverse exactly that same posture. They found out that they had given the increases to a point where the increases on the HUD was larger than it was on the market.
Yep.
So they did the market reverse. I mean, so why are we in a city giving them an increase every year without justification? If you can't justify why you need it, why do I give it to you? And I'm saying that the only way we could do the replacement reserve, building that fund would be a way, but we would do it over an incremental part of time to meet your needs about the older properties.
Yeah.
We could still get it there. Just a thought.
I'm going to think through it. So I think you are working with Department of Buildings to identify housing providers that should be deemed liable for housing conditions. Are you seeing individuals or companies that are repeat bad actors?
I'm not that far into it yet. We're just at the point of getting started. Brian and myself and his team have had one meeting. And then he had the hearing before the committee, so they were occupied. We're getting back onto this. They have my algorithms of the areas that I'm looking at for the data analysis. And once I get that and I get the properties dropped into that, I'll have more information to find out the cause of the closures, which is a very important part, to see what closures were. And then not only the cause of the closures, how many of those buildings that were closed have been reopened, and how many of those buildings have not been reopened, and then how many of those buildings are now listed as vacant or blighted.
What's the rough timeline for that?
My ability to get this part of the project done so that we can report back to you. I was hoping to get it done before the end of the year so that by the end of the year, we could talk about the launch of the reimbursement program, but we need a year to get all of that information together. So that's what we're working on the research side now.
Okay. Last year, we worked to expand OTA's authority to hold landlords accountable for extended hotel stays using your emergency housing assistance fund. I think you talked about what you were expending in that fund, but how is that going?
I'm sorry, say that again?
The emergency housing assistance fund,
What about?
I think we expanded your authority.
Oh, you gave us $30,000 more.
No, it's the number.
Oh, the number,
No. So I believe you now have expanded authority.
to 60
Hold
days
and
now.
it's accountable.
60,
Lena.
the lien authority you're talking about.
So when you have to pay for
Yes,
housing, a landlord's tenant,
yes.
I believe you now have authority to go back to that landlord and say, you gotta give us that money back.
That's correct, up to 60 days.
Oh, yeah.
Yeah,
How is that? Are you using that authority? How's it?
yeah, we've just started that.
Okay,
Yeah, we've just started that whole process.
okay.
Because one of the problems, it wasn't a problem, one of the programmatic areas, council member, that we hadn't finished, the Office of Attorney General had been working with Joel on certain regulatory aspects of what we were doing. And when the pandemic came, it sort of put everything on hold. So it sort of stopped us in our tracks. And now we're back online. We have to reconnect with the OAG's office, I believe, just to make sure that our lien authority prescriptions are in place properly. But we have already engaged in, as I indicated in my testimony, we will be getting a refund from one housing provider in FY24, and this is based on a fire. It's not even the closure.
Hmm.
In this case, it's a Nantahala Boroughs property, and in that case, we're submitting to the housing provider the individual hotel manifest for each one of the tenants involved, and he's submitting it to his insurance company. So we're actually going to get the
Good.
money back.
That's great.
Yeah, I'm very happy about that. I'm tickled pink about it.
And so they're
Yeah.
having to deal with their insurance company, not you. having
That's
to deal with
exactly
their
correct.
insurance.
That's
So
exactly correct. So now I'm recognizing I may be able to ask where the fire was. And in that case, the fire was based on the installation of the solar systems.
Hmm.
It's a really, really, very odd kind of thing. I said, wow, something happened with that installation. But where we have that situation, I can now even look at fires, because I wasn't looking at fires at all.
Yeah. Okay. Let me go backwards for a quick second. Replacement reserve fund. I'm intrigued by this, for existing buildings. So if council required building owners to build up a maintenance reserve fund over a certain period of time,
Yes.
building owners will likely say to their tenants, we're gonna have to raise your rent because council is making us. What would be the response to that?
I think the long-term investment is worth it. We're not talking about a lot of money. That's why I said we could do it incrementally over a period, let's say 5 years. We give them 5 years, but it would be based on the housing provider would first have to invest in doing a replacement reserve analysis
Right.
with a reputable company.
Mm.
That would be the basis for which we would determine what that increase would be.
Yeah.
You see that now you have a reason to talk about whether or not we will improve the rent increase. And again, I think the council needs to start thinking about whether or not the automatic adjustment should be continuing. Because you see, one way or the other, you can kill a rent increase. You can kill, but because if you can't justify why you need it, why in the heck should I give it to you?
Right.
That's what I'm saying.
I hear what you're
They
saying.
they come in and they file it. That's all they have to do. They don't have to tell us anything. And I don't see any major improvements they're using the rent increase for. They do it just because they can.
Right.
And I'm saying that everything in the world that we deal with today, there is a justification for why they increase cost. It's the only place I know where you don't have to justify.
More to come on these. Those are all the questions I have.
You sure?
Yeah, I'm not looking out the window. If it's light outside, this will be our first hearing that ends when it is light
I don't
outside.
think it's light outside.
But I do want to thank you and your team for being with us and very much for the work that you all are doing. I also want to thank public witnesses who joined us today, people who joined us virtually, and want to mention that anybody who wants to submit testimony regarding any of these agencies can do so, and it will be made part of the official record as long as you send it by Thursday, February 15th. If you are interested in sending written testimony, send it to the Housing Committee at there it is, at our new hearing management system at lims.dccouncil.com/hearings. So LIM as in Michael S. .dccouncil.com/hearings. Is it .com or .gov? It's .gov. Thank you. I apologize about that. lims.dccouncil.gov/hearings. And with that, the business before this committee is concluded. The time is now 5:53 p.m. and this performance oversight hearing of the committee is adjourned.